introduction, please ask at the bullet counter, request the time that you're requesting. Then when they call your case and you're ready to come on, that's when you make the introduction. Okay? I mean, I guess you could actually walk with your attorney over here, introduce them, and then just. Okay? Sometimes it's the way I said before, it depends. Rise. The Justice of the Appellate Division, Supreme Court, First Department. Hear ye, hear, all persons having business with the Appellate Division. Draw near, give your attendance, and you shall be heard. Please be seated.
Good afternoon and welcome to the Appellate Division, First Department. Good to see everybody here. We have over 5 hours of oral argument scheduled, so I will ask you to please limit the time you ask for what you really need. Remember that we've had your briefs and your records, and we are familiar with the cases. For those of you who may not have been here before, we do keep time, and when the light turns white, it means you have 2 more minutes. When the light turns red, that means your time is up. If we still have questions, we will continue asking them, but we ask you to, finish up your sentence when the red light goes on. Okay, the first case for argument is People versus Carletta Allen. Please stand up and tell me how much time you're requesting. Guess none. So that case will be marked submitted. Berger versus New York University. Yes. Okay, I'll give you 5 and 2 and 5. Thank you. Elon Properties versus Benishai and Benishai versus Curtis West. Who's here on the first case, Elon Properties versus Benishai? You represent Mr. Benishai? How much time do you want, please? 5 and 2, and keep your mask on, please. Okay, well, I'll give 5 and 2 for the appellant and 5 for the respondent. On the second case, you're also the appellant on that, correct? Yes, Your Honor. So how much do you need on the second case? Well, we're going to argue them, I guess, together, but I know there's a different respondent. There's an additional respondent on the second case. So, all right, so I'll give you 4 minutes on that if you need it. So, and how much do each of the respondents want?
Well, I'll take 2, and the other lawyer. Yes, Your Honor, for respondent margin, we have 3 minutes.
Okay, very good. So 4, 2, and 3 on the second case. Okay, please be seated. Thank you all very much. Pope Investments versus Belmont Partners. Okay, and the respondent? Good afternoon, Ted New York, respondent, I am global counsel here. Yeah, we'll deal with that when the case is called. Sorry, Mark. 5 minutes for the respondent. Okay, 5, 2, and 5. Thank you. People versus Matthias. Yes? Okay, I'll give you 6, 2, and 6. Thank you. Sebro versus Sebro? Sebro, I'm sorry.
5 minutes for argument, 2 for vote.
Okay,
Respond in 5 minutes, please.
you got it. 5, 2, and 5. You figured out the program, right? Thank you. Tavares versus LIC Development? Okay. Request what? Okay, you got it. 5, 2, and 4. Thank you both. People versus Williams? Yes. Okay, 5, 2, and 5. Thank you. Jackson versus Hunter Roberts? Okay. You got it. Thank you. Basile versus Legacy Yards. I believe we have 2 appellants in this case. Oh. Maybe not. Who are you?
I'm an appellant.
Which appellant? Who do you represent?
I represent Legacy Yards.
Okay. Are you the only one here? Apparently you are. So do you want to submit or do you want to 2 minutes to argue? That's up to you.
A late appearing respondent will not be allowed to argue.
Excuse me?
If the respondent shows up.
Well, no, they have to be here at the calendar call, so. Okay, so we'll mark that submitted. Thank you, counsel. Kurland and Associates versus Glassdoor.
For the appellants, request 8 and 2, please.
You're the plaintiff appellant?
I'm the appellant's defendants, cross-respondents.
Well, so who's the plaintiff?
I'm the appellant. It's Glassdoor.
Aren't you both appellants? Yes. So you represent plaintiff appellant?
Yes, that's correct.
Okay, so how much time?
6 and 4, Your Honor.
Oh, okay, so I'll give each side 6 and 2. If we have additional questions, we'll keep you on. Thank you. Henry versus Split Rock is submitted, and Newman versus Mount Sinai is submitted. Okay, the first case for oral argument is Berger versus New York University. Yes, please step. Okay,
Thank you very much, Your Honor.
you may introduce yourself and proceed.
Good afternoon, Your Honor. My name is Garrett Kennedy from DLA Piper on behalf of Appellant Defendant New York University. Thank you for the time today. We are here today on appeal to respectfully ask that the court overturn the lower court's decision on an application to stay arbitration in the pending dispute involving New York University and a former employee, Richard Berger, who is seeking to represent a putative class. There are 4 principal reasons as to why we submit that the lower court erred. The first is that the court failed to consider the threshold issue of arbitrability and which forum was the appropriate forum to do that. Under the governing CBA, for which applies to Mr. Berger as a union member.
Well, in order for, you would like the question of arbitrability to go to an arbitrator and not the court, but don't we need, in order for that to happen, don't we need much broader language than is found in the collective bargaining agreement involved in this case?
No, Your Honor, we do not. Under the collective bargaining agreement here, it provides that any dispute or difference concerning the meaning, application, or operation of the collective bargaining agreement must be referred to arbitration.
Well, as to that point, is there anything that is in the record which states that the collective bargaining agreement or that the union members agreed to that, to arbitration?
Have they agreed to arbitration in the current instance?
Period. Is there anything to substantiate that the union members agreed to arbitration? Because Mr. Berger is a union member, is he not?
Yes, he is, Your Honor. And
So is there anything that indicates that he as well as the other union members agreed to arbitration.
Yes, Your Honor, by virtue of this collective bargaining agreement having been ratified by them and applying to them.
So is there something explicitly that states that the collective bargaining agreement applies to them?
Well, yes, Your Honor. I mean, the collective bargaining agreement governs the terms and conditions of their employment from the get-go. It is the document which comprehensively governs them, and there's substantial case law providing that collective bargaining agreements entered into by a union representing a plaintiff, an employee such as Mr. Berger, would be covered by the applicable CBA. And the CBA here, to the court's earlier question as to whether or not the CBA is broad enough here, Judge Etkin of the Southern District of New York already looked at this very issue in a dispute between Local 1 Securities Officer Union, the very union here, and New York University. And he expressly held that, under the terms of the CBA, by virtue of the fact that there was a dispute over whether or not its terms applied, that in and of itself was sufficient to compel arbitration on the threshold issue of arbitrability. So we respectfully submit that that issue was correctly decided. Plaintiffs' counsel have suggested that that issue should not be considered here because in that dispute, the dispute between the parties was contractual and not purportedly statutory, and we would dispute that the claims here are statutory in nature because there is zero authority for any of these claims giving rise under the New York labor law. But setting that aside, Judge Etkin expressly disclaimed that he was relying on the question of whether or not the claims were statutory there. He expressly said that didn't matter. All that mattered was that there was a dispute over the scope of arbitrability, and that in of itself was sufficient to submit that threshold issue. So that is the first issue that we would submit, and we'd also note that the CBA does explicitly reference the AAA rules, which in of themselves additionally require that provide that an arbitrator has the purview to determine the scope of arbitrability, and that in so doing, a number of courts, including the Court of Appeals, have held that in such instances, a matter should be submitted to arbitration, if not simply to determine whether or not the dispute is arbitrable in the first instance. So we respectfully submit at the first instance that the court failed to consider this, even though it was argued in brief before the lower court, and that issue here should be dispositive. While we don't believe the lower court should have reached the merits, we do believe it also failed to consider that the claims here are in fact contractual in nature and not statutory. While plaintiff does plead them under the New York labor law, all of the claims here are expressly addressed in the collective bargaining agreement. The collective bargaining agreement explains what is and is not compensable time, including whether or not one must be paid for time donning and doffing.
Where in the collective bargaining is that agreement that this particular dispute between the parties has to be arbitrated? I want to know. I may have missed that, but
So the Article 6 of the CBA provides, that has the arbitration and grievance procedure. And it provides, and that would be at page 135 of the record, Your Honor. And my time is up, but I have...
Okay, well, you'll have a couple minutes for rebuttal, and so you can respond to that question a little bit more at that time and any other questions we may have. Thank you.
Good afternoon, Your Honors. May it please the Court, James Emmett Murphy for the respondents. The claims here are purely statutory, and that was found as a matter of necessity by Judge Etkin in the Southern District on our motion to remand the underlying action after it was removed by NYU to federal court. A necessary part of his holding, which they didn't appeal or otherwise challenge, was that our claims arose purely under the New York labor law and did not arise at all under the collective bargaining agreements. They keep trying
this issue about putting on their uniforms and the time that it takes them to do that is something that was excluded from the collective bargaining agreement in this particular case?
The collective bargaining agreement has some definitions of what it constitutes, of what it believes to be compensable time. But a collective bargaining agreement can't say, we're not going to compensate you for time that you spend working on Saturdays and Sundays, because there's a statutory right that workers have to receive compensation for that time. Here, we've alleged that the workers have a statutory right to receive compensation for donning and doffing time and travel to and from roll call, and at the beginning and the end of their shift.
But counsel, doesn't the CBA make an account for that? They'll be paid for if the worker leaves 15 minutes early, as allowed to change their clothes, or to during the 15 minutes of roll call?
So our claim here is that they had to show up at the locker room at the beginning of their shift, and they had to leave the locker room at the end of their shift, and they didn't get paid for all of that time in between. Whether some portion of that may have been compensated or not is a fact issue that has nothing to do with the arbitrability issue that's before the court. We're strictly saying that people had to show up at the locker room at 6:30 before a 7 a.m. shift. They had to go back to the locker room and leave at 3:20. They didn't get paid from 6:30 to 3:20. They got paid for some lesser time than that. It's a pure statutory wage claim. The fact that there may not have been a specific case before saying whether this specific donning and doffing and traveling back and forth from a locker room that's often blocks away from the roll call facility is compensable or not, doesn't mean it's not a statutory wage claim. It has nothing to do with the collective bargaining agreement. We didn't allege any violations of the collective bargaining agreement, and Judge Etkin necessarily found that our claims were completely unrelated to the collective bargaining agreement. If they were related to the collective bargaining agreement, then the claims would have been preempted under Section 301 of the Labor Management Relations Act.
So your claim is that under the collective bargaining agreement, it makes, it accounts for 15 minutes before and 15 minutes after, but you're saying that it's taking longer than, in actuality, 15 minutes before and 15 minutes after?
It's taking, there's a 15-minute after the end of whatever they were defining as the shift period under the collective bargaining agreement. Our claim is that between their first job duty and the last job duty of the day is longer than the amount of time that they're being paid for.
Okay. So now your adversary had started to reference Article 6. So Article 6 states that any labor dispute between NYU and the union or its members is subject to arbitration.
No, it only says that disputes arising out of interpretations of the collective bargaining agreement are subject to arbitration. This is not a dispute arising out of the collective bargaining agreement. The specific language is subject to arbitration, any disputes between the employer and the union as to the meaning, application, or operation of any of the provisions of this agreement. This is a statutory claim which does not involve in any way interpreting or having a disagreement about the provisions of the collective bargaining agreement. Defendants completely ignored Judge Etkin's decision in the Berger versus NYU underlying matter. They focus on the Local 1 versus NYU matter where Local 1 tried to get a stay of arbitration that NYU demanded regarding Local 1's obligations with reference to this lawsuit. In that case, Judge Etkin specifically said that because the NYU had disclaimed any attempt to arbitrate statutory claims, that issue was not before him, and so he didn't have to decide it. Here, all we have are statutory claims. There's no allegation that there was any misconduct or violation of the collective bargaining agreement. There's no allegation that there's any need to refer to the collective bargaining agreement in any way to determine the claims of the plaintiff.
But who should decide the question of arbitrability?
The
Now,
question
it's a matter of interpretation of Article 6. Should it be for the court or should it be for the arbitrator? Your friend indicated in his argument that Article 6 contains clear and unmistakable language.
In essentially identical cases to this, there's Heaches and a long line of home health aid cases that have been decided by this court in the last 2 years on that specific issue with largely identical provisions, said that when you have a statutory claim and the collective bargaining agreement requires arbitration of disputes under the collective bargaining agreement, that is not an arbitrable claim. The only difference here is that there is a reference in subsection B of step 3 in the grievance procedure that says that if the individuals submit a claim to arbitration and they cannot agree on the name of an arbitrator after 5 days, then the name of the arbitrator gets picked pursuant to the AAA rules. It does not incorporate the rules of the American Arbitration Association.
Okay, thank you very much. Counsel, you have 2 minutes.
Thank you very much. I would like to address a few things that my colleague said. First, he said that Judge Etkin held that these claims were purely statutory. That is incorrect. What Judge Etkin held was that on a remand motion, he did not have sufficient evidence at that time to determine whether or not there was preemption under the Labor Management Relations Act. What he says in the end of his decision is that even though it may eventually turn out that evaluating Berger's claims under the New York law will require interpretation of the CBA, such that it ultimately becomes clear that the claims are indeed preempted, NYU has not proven that point at this time. In other words, he did not rule that anything was purely statutory, and that is a clear overstatement of what he said. I would like to also address the issue about what time is or is not compensable under the CBA. The CBA especially provides that people are not to be paid until after they've donned and are at their roll call. It expressly covers what is and is not compensable working time. This is not a strictly statutory claim here because there is no There is no authority whatsoever saying that people must be paid for donning ordinary uniforms, which we're talking about here. We're talking about shirts, shoes, pants, nothing else. There's nothing under the New York labor law that says such must be compensable.
Wasn't that the question? I mean, they're claiming that they should be compensated as overtime.
They
That it
are-
should be compensated as overtime. So that's the issue, right?
Well, their issue is they're saying that they should be paid, but the problem that they're having is that these things arise from the CBA. And I would just point to plaintiff's own complaint, which says that in their allegations that they have not been paid, quote, in accordance with the agreed upon terms of their employment. There is only one document that sets forth the agreed upon terms of their employment. It's the CBA. And
But you're not specifically, but you didn't specifically refer to the CBA.
they carefully devoided those three letters, yes. I do not dispute that, Your Honor, but every single issue and allegation here is derived specifically from compensable time as described in the CBA, and they expressly reference the terms and conditions of their employment under their agreed upon terms and conditions, which only may arise from the CBA.
Okay, thank you both very much.
Thank you, Your Honors.
The next case for argument is Elon Properties versus Benishai. Okay, good afternoon, counsel. You may begin.
Thank you. Good afternoon, Your Honors, and may it please the Court. Today I represent defendant appellant David Benishai, or now his estate, in Elam Properties versus Benishai, as well as plaintiff appellants David Benishai and the Benishai Family Charitable Remainder Unitrust in the related appeal Benishai versus Curtis West. In this appeal, we respectfully request that the Court reverse the trial court's entry of summary judgment against Mr. Benishai. This appeal concerns a phantom promissory note allegedly given by David Benishai to Elan when Elan was a family-owned business, which the new controlling shareholders seek to...
It isn't part of the many, I know this is a long-going dispute between these parties, and there's been a lot of things that have gone on, but when you were before, I think, Judge Kornreich in Supreme Court, didn't she say your client, Mr. Benishai, was taking very different positions, and he was now stopped from claiming that he didn't sign the promissory note that now he says is a phantom promissory note?
Your Honor, that's partially correct, Your Honor. Mr. Benishai did testify that he signed a note virtually identical to the one his brother Jack Benishai signed. That note has been produced. David Benishai has not. However, even though Judge Kornreich stopped Mr. Benishai from asserting that he had never made the note, she did not in any way say he couldn't raise any defenses to the note, such as satisfaction, release, etc. So in this case, the note that...
But you're not claiming satisfaction.
You're claiming that the note didn't exist.
Your Honor, we're claiming that the note was released under the settlement agreement between the family members.
Oh, really?
Yes, Your Honor.
The note didn't mature for 5 years, correct, by the time that the releases were issued?
I beg your pardon, Your Honor, I didn't catch the last bit of that question.
When were the releases issued? When are you saying that this promissory note was released, that he didn't have to pay it? When are you saying that happened?
As part of the settlement agreement among the family members, which would have been March 2009.
And where, I have a copy of the settlement agreement. Where specifically did it release this particular promissory note?
Sure, Your Honor. Well, if you compare paragraphs, and this is, I believe, record 227 and 228, if you compare the releases that were to be given to Jack Benishai, who was not only receiving shares free and clear from the mother's estate and paying off the sisters, as well as $100,000 to David, he only gets released by the siblings. In contrast, if you look at the release from to David, Elan also releases David, unlike Jack. So in that case, where David is not inheriting any property from the mother's estate, and his brother is obtaining something, it only makes sense, and that's what's been testified to in the trial court, was that he was supposed to have been forgiven the debt, whether that was for...
That was testified to by whom?
Well, that's in the documents, Your Honor, and David Benishai.
Right, exactly. So, I mean, again, you're saying this all flows from that testimony and it only makes sense, but where is it concretely stated that it was released?
Well, Your Honor, there's the paragraphs in paragraph 2 and 3 of the settlement agreement, and there are also separate standalone
So,
releases for approximately the same date, if not the same day.
okay, so I'm looking at paragraph 2. Where does that say specifically that that was released?
Your Honor, it does not specifically name the note, but Elan releases David of all obligations, and it says it's effective forthwith.
So again, how do we know that that meant the note?
Well, respectfully, Your Honor, I would say at a minimum it creates a triable issue of fact. This is summary judgment, where the note...
So who put together the settlement agreement?
Your Honor, that settlement agreement, the parties were at least 2 sisters, David Benishai, Jack Benishai.
With attorneys present? I mean, this was done with the attorneys?
Your Honor, I wondered that question myself, and I don't see any indication in the record.
But wasn't this promissory note that we're talking about also signed the same day as the agreement, March 31st, 2009?
Yes, Your Honor.
So how could it possibly make sense you enter into a promissory note of over $1 million and on the same day agree to release it? I mean, how does that even make any sense?
I see my time is up. May I respond, Your Honor?
Yes, you may respond to that
Thank
question.
you. Well, in the context, Your Honor, if you look at Jack Benishai's note, first it calls itself a promissory note, and then there's a loan agreement, which is then struck out and replaced by promissory note. It would appear that the promissory note is not only to reference monies being dispersed to the brothers, but also an obligation in the future, because the money that was loaned to David and Jack did not exist at the time of the settlement agreement.
That doesn't make any sense.
It came after.
I don't understand. How does that make any sense? How is it a promissory note for monies in the future when it's being released on the same day?
Because the money wasn't available until after the siblings refinanced the
But why sign a
property.
promissory note for illusory funds?
I beg your pardon?
Why sign a promissory note for illusory funds?
Well, Your Honor, in the context here, this is a family-held company where they're borrowing money essentially from themselves. So there could be many bona fide reasons to do that, such as tax planning, asset protection. That's not elaborated in the record. But the context here is where it's changed from people borrowing money from themselves to a third party who never even knew the note existed, purchasing it, and then finding out about it later and seeking a windfall by enforcing the note.
Okay, you'll have a couple minutes to respond. That's why I separated it with each case, because they're different issues. We'll hear from counsel for Elan Properties. You also have 5 minutes. You may proceed.
Okay, may it please the court, my name is Philip Eiler from Miltenberg, representing the plaintiff appellant Elan Property. Justice Schechter correctly granted summary judgment on 2 promissory notes, rejecting as feigned arguments that David and Jack made. Now, we're dealing only with David. She cited the settlement agreement and the judicial estoppel ruling as the grounds for rejecting David's arguments. Settlement agreement is very simple. The releases covered the existing obligations at the time the agreement was executed. Notes in paragraph 16 did not exist yet. Neither did the rents in paragraph 15. They were expressly contemplated in the settlement agreement to be done in the future. They would take out leases and therefore be obligated on rents. They would do a refinancing and take notes, and they were obligated on the notes. It's that simple. It's a legal interpretation of an agreement. Judicial estoppel, quite frankly, this case is one of the most compelling cases for judicial estoppel. David Benishai came in at the start of the case, and he represented in testimony, sworn testimony, he took out a note identical to Jack Benishai. He said, here's Jack's. Mine's identical. It was a promissory note, very specific, clear. And that was contradictory to what he later tried to say. That testimony was relied on by Justice Kornreich in her November 14 opinion. Pages 51 and 52 of the transcript are the portion of her opinion discussing the notes. What's more, we had years of litigation over whether the notes had been extended in terms of their maturity.
I guess the settlement agreement didn't do a very good job of settling the disputes between these parties.
Well,
did it?
no, but it wasn't meant to deal with the notes. When it was executed, they didn't exist.
Well, the notes were executed the same day as the settlement agreement, right?
No, it was later because they had to do a refinancing.
Well, wait, according to the record, it was the same day. According to the record, the promissory note was executed the same day as the settlement agreement.
March 31st, 2009, that's the
Right.
date on the settlement agreement.
Correction. That was done after the settlement agreement execution. It was not contemplated in the settlement agreement that those notes would not be obligated on. It was clear that those notes had a continuing obligation. And the settlement agreement in the releases did not say, and it was a matter of draftsmanship if they intended to, did not say, oh, you're released on the notes. David Benishai never argued during judicial estoppel that those notes we were released them. No, he didn't argue that. He just said, oh, I took a distribution.
Well, that was my question as to drafting, and your adversary points to the fact that the settlement agreement says that it releases him from any and all obligations. So any and all obligations, according to him, would include the promissory note.
No, it would not, because the obligation was to repay those notes. The language there is to deal with the existing obligations that already were existing. Contemporaneously, they take out the notes in terms of a restructuring of the company, the financial restructuring. At no time in that settlement agreement is there anything to indicate that, oh, those notes aren't real, because that's what that would be what would be the effect of that kind of release. Now, as I said, in judicial estoppel time, David didn't argue that. He just argued, oh, I took a distribution. He could have, but he didn't argue release. It was something thought up after the fact. And it could have been, was not presented to Justice Kornreich, and this was a clear and compelling case for judicial estoppel, because here it is, we have years of litigation over a note which David never said, oh, I got released on, and then later he says, I got a distribution on, and even then he doesn't talk about a release. It's just an after-the-fact argument trying to, seize upon a few words when it was clear throughout this litigation that note obligation was real. And that's what Justice Schechter correctly ruled on summary judgment was the obligation to repay.
Okay.
And there was no basis now to disturb that on appeal.
Okay.
Thank you.
Thank you very much. Counsel, you have 2 minutes to respond to any of his arguments.
Thank you, Your Honor. I would just point out that my friend here's version is speculation based upon third parties who have come in long after the execution of not only the settlement agreement, but the notes, who didn't even know that the notes existed, have no personal knowledge of the party's intent, whereas David Benishai has testified and held that the note was released, and Jack Benishai, his brother, who was supposed to have had the note, who had feuded with his brother for decades, never bothered to preserve the note, never even gave it to the purchaser of his shares when that would have benefited him by increasing the value of his shares, because that's a receivable of $1.1 million. So it's, at a minimum, there's a triable issue of fact before granting an extraordinary remedy of summary judgment on a note that's not been produced based on testimony without personal knowledge. Again, estoppel has not been contested, has not been preserved on appeal. We're not contesting that we're stopped from saying there was a distribution, but nowhere did Justice Kornreich preclude Mr. Benishai from raising any affirmative defenses, which would include release.
Sir, is there any tension between your argument that the settlement agreement covers the notes and the principles that releases are not lightly presumed and that releases must be reflected in a clear and explicit manner to capture an individual claim?
I don't believe so, Your Honor, because the release is very broad, and it's also consistent with the general facts of the case. And for instance, that Elan released, specifically the releases David and not Jack, whereas the siblings all released each other. So I think there's harmony there. When the scope is so broad, I don't think there's any tension.
Okay. All right, thank you very much.
Thank you, Your Honor.
So now we're going to go to the second case. And yes, why don't you just have a seat back there? Thank you, counsel. So we're going to give you, I've given you 4 minutes on that case. So now that we're familiar with this, why don't you go on to that second part of the case?
Thank you, Your Honor. And again, may it please the court, this second appeal concerns largely the same parties and facts. However, in the action below, David and his trust brought suit against the then majority shareholders for breach of fiduciary duty, waste, and self-dealing, as well as against Argent Ventures, to whom he...
So the judge, Judge Schechter, found that the fiduciary duty claims were barred because of the statute of limitations. So how do you get past that?
Sure, Your Honor. The case law is quite clear that the time for fiduciary duty claim to begin running, it ends when the fiduciary relationship ends. For example, in Westchester Religious Institute versus Cameraman 262, 82nd, 131. Here, it's not disputed that the fiduciary relationship actually is still in effect. Argent and Curtis West are still the supermajority shareholders. David Benishai's estate and trust retain a couple percent, and Jack Benishai a fraction of a percent. So the fiduciary relationship never ended, and particularly in a case like this, where the majority controlling shareholders have abused their position to stonewall all requests for information, it's a particularly apt place to apply that doctrine.
Well, you conceded that the 3-year statute applies, right? Is that correct?
That's correct, Your Honor, because we're seeking monetary relief.
Okay, so then we're talking about what is the continuing wrong, therefore, that you're arguing occurred?
It's a continuing relationship, Your Honor, because they were, at the time, they were shareholders and continue to be majority shareholders. And in addition...
No, I'm saying, but in order to toll the statute, don't you need a continuing wrong or continuing wrongs?
And what is
what is the continuing wrong, therefore, that you are alleging, which would toll the statute?
Your Honor, my understanding is that there are distinct doctrines between the continuing wrong and the continuing fiduciary duty. But the continuing wrong was that the waste, of course, the interest fact.
But how did you not know about that interest? I mean, you took that loan in 2014. It took you 5 years to figure out how much you were paying on interest on the loan?
Your Honor, as the record reflects, Mr. Benishai asked for a bargain for statements that were not complete or not exhaustive. In addition, asked for follow-up information, which was never forthcoming. So he did what he could to find out, and when he did find out, he brought suit.
Well, prior to when you're saying that he did find out, was there any allegation that he was induced by fraud or deception not to commence an action sooner to find out that information? I mean, clearly there was something wrong.
Your Honor, this would be a case of a fraud by omission because there's a fiduciary duty. There's a duty to provide true, complete information that was not complied with by the majority shareholders. Moving on.
What was the information? The difference in the interest rate? Was that it?
That's one of the issues, Your Honor, is the
So that's
difference.
plain on whatever paper was signed to obtain the mortgage.
Your Honor, that was not signed by Mr. Benishai, to the best of my recollection. That was signed by the that would have been done by the majority shareholders, Curtis West and Argent. May I proceed, Your Honor?
Do you want to finish answering his question?
Yes, Your Honor.
Okay, go ahead.
I would just add that what was supposed to have been an interim issue of finding a bridge turned into a years-long issue held by an entity that was not disclosed to Mr. Benishai. It was related to Curtis West.
Okay, you'll have a minute to respond.
Thank you, Your Honor.
Okay, Mr. Byler, are you going to go first? Yes, I'll go first. And then we'll let your co-counsel go? Okay.
Justice Schechter, may it please the court, I'm sorry. Justice Schechter correctly granted a motion to dismiss on the ground of statute of limitations. The loan was made in 2014. The lawsuit was brought in 2019. She said no basis for tolling. Absolutely right. There's no continuing harm here. They're relying on, first and foremost, a law firm case where there's a continuous representation. Justice Schechter, in the oral argument, look, the loan was made in 2014. And what's more, the documents show David Benishai knew about it. But I'm not going to rely on that. He had every reasonable opportunity to, see the facts. And there's no basis in this complaint to say he didn't have that opportunity.
Now, what about counsel saying that they were trying to get the books and records, because I think the claim is, at least in part, that you actually made the loan and didn't do it through the bank, and if you didn't provide those documents to them, then were you preventing them from getting the information they needed?
That does not give rise to a breach of fiduciary duty claim. That they did bring a claim for accounting, and they're not pursuing that appeal. We're dealing with a breach of fiduciary claim over the 2014 loan, made in 2014, that, I repeat, the documents showed David Benishai knew about. But the court said, no basis here to say David Benishai didn't have a reasonable opportunity to see the facts. And there's really no allegation that there was anything misrepresented. All that happened was Stellar Capital took over a loan at the same interest rate. They're raising a fuss about something which David Benishai knew about and was no big deal. 2014, no suit until 2019. Where's the basis for tolling? It's not there. It's not there. You can't rely on cases where there's some kind of continuous activity like a law firm continuing to represent a firm and doing the same malpractice. That was the Palmieri case. This is a case where the loan's made in 2014, and that's it. And that was what Justice Schechter reacted to at oral argument. I've probably exceeded my time.
Okay, thank you very much. Counsel for Argent.
Good afternoon, Your Honors. Craig Kesh from the law firm Ganfer, Shore, Leeds, and Zatterer for Respondent Argent Ventures. Good to be back, Your Honors, although I would say that because I did not hear anything from my adversary concerning Argent on his argument, even though prepared as I am, unless the court has any questions, I would be happy.
The case against, the cause of action against your client is breach of contract as opposed to any breach of fiduciary duty, correct?
Yes, Your Honor, that's exactly right. And, well, it's styled as a breach of contract claim, Your Honor, but what it really is, which is what the court found it's really a defense to the action that was heard earlier on appeal, what we have called the note action, right? Which is that 5 years after the note action was brought, appellants have brought this action in 2019,
Saying that the first action was not authorized, something like that?
That's exactly right. They said that Alon should have never had the authorization to bring the action because under a share purchase agreement that was entered into, pursuant to which Argent purchased David Benishai's shares, David Benisha, or it was agreed there that Argent would not vote its interest to require repayment of the $5 million partner loan until the sale of the property being the buildings on the Upper West Side. And what the plaintiff and what the appellants claim in the complaint is that the $5 million loan are the notes at issue. And so, of course, there's infirmities there right off the bat, which is that, as we've discussed before, the note was due, payable, on March the 31st, 2014. The note action was not even brought until June 2nd, 2014, and Argent's purchase of David Benishai's shares did not close until September 3rd of 2014. That's all conceded in the complaint. Paragraph 11 of the complaint confirms that. So for this court to believe that Argent breached an agreement by voting its interest for Elan to pursue the note action, you'd have to believe that a vote was required to require payment of a note that had already matured, that Argent could vote an interest it didn't even own yet, and that Argent's vote was even needed in the first place. In other words, this is basically, as the court said, it doesn't even matter, because the action brought against Argent was nothing more than a defense to the note action. David Benishai litigated the note action for 5 years, introduced everything under the sun, as we've heard. It was a distribution, it was a note, never once said it was unauthorized. Never once. And I see my time is up.
Just finish.
Yeah.
Just finish your thought.
And of course, as the court said, even if this court or the trial court were to overlook the waiver, which is what they want, they say, well, we've adequately pled the elements for breach of contract. The reality is they haven't. They've conceded that they have no damages, and there's other infirmities, of course, as well. I'm obviously happy to answer any questions that Your Honor may have on that.
Okay, well, I think you've answered them, so thank you
Okay.
very much.
Well, thank you very much.
Counsel, I'll give you 1 minute to respond briefly.
Thank you, Your Honor. Very simply, the concept that a breach of contract claim against Argent because they breached the voting trust agreement to vote to enforce a note against David Benishai, that is actually superseded by the Business Corporation Law. Section 203 expressly states that ultra-virus is not a defense in a claim. A defendant from a plaintiff corporation cannot attack the corporation's authority by its internal documents as a defense. However, and also, the ELAN is bound by its certificate of incorporation and its bylaws, not agreements among its shareholders. Furthermore, the chronology is also key because the original Curtis West complaint in 2014 was brought in June of 2014 before Mr. Benishai sold his shares to Argent. However, there was a closing in late 2014. May I finish my sentence, Your Honor?
Yes, go ahead.
Was in late 2014 when Mr. Benishai sold his shares to Argent, and then the amended pleading pursuing the note against Mr. Benishai was brought in November of 2015. Thank you, Your Honor.
Okay, thank you all very much. Have a nice afternoon. The next case for argument is Pope Investments versus Belmont Partners. Yes, you have an application to make, I understand.
Yes. Good afternoon, Your Honors. May it please the court, my name is Ted Eder. I am local counsel and an attorney with the law firm Weber Gallagher for the plaintiff respondent, and I have with me here today, already granted pro hoc vice admission, Andrew Protzman, and with Your Honor's permission, I'd like to introduce him
to the court to allow him to argue on behalf of the respondent.
Okay, and where is Mr. Platzman from?
I'm from Kansas City, Your Honor.
Okay, well, came all the way from Kansas City to see our beautiful courthouse, so we're certainly happy to grant you pro hoc vice, and you'll be permitted to argue. If you please have a seat, we're going to listen to the appellant for us, of course. Thank you.
Good afternoon. May it please the court, Ellie Herman from Wilson Elster for the defendants appellants. And Your Honor, I'm very happy to be back in this beautiful courtroom. It's one of the few rooms that I truly missed.
So what took you so long? This case was decided in 2014 and is now 2022. What is the delay?
I had a feeling I was going to get that question, Your Honor. I wish I had a better answer than I wasn't involved in the case at the time. I haven't spoken with any of the series of prior counsel, and I prefer not to judge too harshly.
Was there actually some type of trial or other proceeding in this case?
There is a trial that was scheduled for June that this
And you've
court,
stipulated to adjourn that.
Yes.
So how do you have a case, an appeal on a motion to dismiss a complaint and have a trial scheduled at the same time? We can't figure out like what was going on. What were you going to have a trial on?
well, Your Honor, we were going to have a trial on everything that remained after the summary judgment motion, which has also been decided.
The summary judgment motion has been decided, but the motion to dismiss the complaint, the amended complaint hasn't? Wow.
The motion to dismiss the complaint was decided in 2014, Your Honor, but the notice of entry was never served, so we served notice of entry and notice of appeal and appeal directly from the motion to dismiss.
Okay. Well, all right, so get on with it then.
Yes, Your Honor. As the Southern District noted in dismissing the federal case preceding this case, the claims are so broad and conclusory as to be meaningless. While the pleading standards are slightly different, Your Honor, that is true here as well. The plaintiffs chose not to exercise reasonable diligence or conduct any due diligence of their own, instead choosing to rely entirely on all of the defendants, including the two remaining defendants, which I represent, and to attempt to make them the insurers of a very complicated transaction. The plaintiffs are not, mom and pop investors, Your Honor. They're an extremely sophisticated group of funds and other entities, and they put together in excess of $10 million and have chose to essentially, at least as they tell it in their complaint, put their heads in the sand and ignore everything and say, no, we just listened to what the defendants told us. We didn't bother to do our own investigation before we handed over in excess of $10 million. I don't need to regurgitate all the arguments in the brief. I know that there are some quirky procedural issues addressed in the briefing. If there's anything specific, I'd be happy to address it before I cede the podium.
Anybody have any questions? All right, then why don't we hear from your adversary, and then if you want to respond to anything.
Thank you, Your Honor.
Fine. Okay, thank you.
May it please the court, thank you for letting me come and appear before you in this, like you said, beautiful old courthouse. I'll just address the things that have been addressed very briefly, and then if you've got questions, I'm happy to answer.
Well, let me ask you something.
Sure.
The negligent misrepresentation, the defendants did not move to dismiss that cause of action, so we assume that's in?
We would assume that that is in, Your Honor. Yes.
And the breach, this is where this case gets weird, one of the ways, the breach of fiduciary claim, which is they were moving to dismiss, has already been dismissed on a summary judgment motion.
That's correct, Your Honor.
Before. So that's out, right?
Judge Maisley granted summary judgment on fiduciary duty. There was no motion filed in the below court back in 2014 on the negligent misrepresentation count.
So we're really focusing on the fraudulent inducement and professional malpractice claims?
That's correct. And when we talk about these claims and those being the subject, really truly the subject of this appeal, Your Honor's first point about the delay is appropriate and significant. The reason that these issues are required to be brought up in 2014 at the trial court is because if the judge finds the pleading to be insufficient, the appropriate remedy is to permit the plaintiff to amend. And so by not filing the motion, they've prejudiced my client with the ability to amend to address any perceived insufficiencies. And that's why it's inappropriate for them to bring these up now.
And the court did find that you had cured the problems with those causes of action as found by the motion court in 2014.
That's correct. That's correct. And frankly, if your honors look through the petition, the elements of fraud are all there. Reliance is pled in about a dozen different locations.
So you're going to need like years of discovery now? Is that the deal?
This case is ready for trial. We were going to go to trial in June. They filed this appeal. So we've stipulated to not go to trial in June until this is resolved, right? But this case is, summary judgment's been decided. Experts on professional malpractice on both sides have been disclosed and deposed. The case is ready for trial once this appeal gets ruled on.
So you already have a professional malpractice claim in there?
Both sides have disclosed and deposed expert witnesses.
On the hope that this cause of action would stay in the case?
When we did the expert discovery in this case, Your Honor, we had no idea that this motion was coming. That this appeal was coming.
A backwards kind of a way to proceed with the case.
We certainly didn't file the appeal, Your Honor. I don't disagree.
Okay. And what about, so you say you've met all the claims, and what about the fraudulent inducement? Do you need more discovery for that, or you're saying, no, we don't need more discovery, just want to clarify what the claims are going to be so Judge Maisley will know when she goes to trial?
We believe that we know what the claims are. They want to clarify the claims. We're ready for trial.
Okay. Does anyone have any further questions? Okay, well.
Thank you very much. Nice to meet you.
Nice to meet you, too. Just wanted to ask you a few questions so you didn't waste your whole trip from Kansas City. At least it's a nice day here in New York. Okay, counsel, you have 2 minutes to respond.
Thank you, Your Honor. Regardless of how the appeal has gotten here after 8 years, it's still here. It's a viable appeal. There's no jurisdictional bar to it being here. I tend to agree with counsel that discovery is largely complete. There's one issue that we're still resolving, but that's Judge Masley is taking care of that.
I'm sure.
The questions on appeal, though, are all they all are preserved. All of the issues are preserved for appeal, Your Honor. Whether or not the claims are duplicative is a pure question of law that may be raised for the first time on appeal. The motion papers included a broad wherefore clause, a prayer for relief, and there are plenty of cases which this court has decided where similar arguments for dismissal under the same 3211 provision. So if you argue 3211A7, but you don't address one of the claims on appeal, this court will consider another claim that was not directly addressed in the motion papers. And furthermore, if you look at the substance of all the claims and the duplicative nature of them, Your Honor, it would be sort of silly to have a trial on these claims. I mean, I think at best we're looking at a directed verdict on everything except for maybe the professional malpractice claim, because all the other claims are the identical facts, they're the identical damages.
Wouldn't that issue about whether or not claims are duplicative of one another been better addressed at summary judgment? This is again, we're back a ways here to the 3211 stage. A record has been probably sufficiently developed as a result of the years of discovery you've had, and so any duplicative claim argument, isn't that better addressed at summary judgment? Or maybe it was?
Your Honor, I take your point. I don't know that it would be better. May I finish?
Yes.
I don't know that it would be better addressed at the summary judgment stage. I do know that it is properly addressed here on this appeal, and given the difference in summary judgment standard and motion to dismiss standard, it's a much neater issue presented in this way, rather than asking the court to do fact-finding or review facts. It's just the four corners of the pleadings.
Okay, well, thank you very much. Have a nice afternoon.
Thank you.
The next case for argument is People versus Matias.
May it please the court, Natalie Ray of the Legal Aid Society for Mr. Matias. The question in this case, Your Honors, is whether the court erred in denying appellant the motion to vacate the sentence without ordering a Miller hearing.
Well, counsel, in light of Jones, which was decided by the Supreme Court, and which held that a state's discretionary system is both constitutionally necessary and constitutionally sufficient, why would a Miller hearing be necessary?
Well, I think that that statement in Jones doesn't eliminate Miller. In fact, the majority itself, it was in the context of Miller. What Jones says is you don't have to make a factual finding as to a transient. You don't have to expressly make that finding. But it never said that now you can sentence someone without taking into account youth and its attendant character.
But in this particular case, didn't Judge Barrett take all those things into account? He wrote a very, this is a motion relating to his 44020 motion decision. And he wrote a very, very thorough decision where he went through all these different aspects that you might have wanted him to consider. What were the things that he did not consider that you feel he should have?
There's no question that Judge Barrett believes he conducted a sentencing in 1994 according to Miller. But he didn't, and he couldn't.
So again, how was it, what was deficient? What more should Justice Barrett have considered? What additional information should Justice Barrett have considered?
Well, first of all, it was in 1994, before the Supreme Court this fundamentally changed the definition of a child.
Of a child.
As children are different.
But again, Justice Barrett went through all of these various mitigation issues, considered the age of the defendant at the time that he killed these two individuals, shooting one in the back twice. He went through all of this in his decision. And he looked to the fact that this individual was 16 years of age at the time. So again, what additional information or additional factors should he have considered?
I understand you're saying that science may have come somewhere in the past almost 30 years in evaluating how courts might want to look at 16-year-olds. I understand that, but even without that, it seems that he made an awful lot of those,
Your Honor,
he
first
took
of all,
those things into concern.
He believes it. He simply couldn't, and what he said in his decision shows that he
Where?
did.
Specifically, what did he say which leads you to believe that he had some subconscious or unconscious feelings towards this particular defendant?
I'm not saying he had unconscious feelings. I'm just saying he didn't take into account that children are less culpable, that they're more, and I will give you exactly what
Thank
he
you.
said.
Where? Please
For example, he focused over, there's no doubt that he knew my client was 16 at the time, but age is not all that we're talking about. So he says he focused particularly and almost exclusively on retribution. He talked about the victims, he talked about the loss of their family, and I'm not diminishing that. All I'm saying is that since Roper and its progeny to Miller, when you're sentencing a child, you have to look at mitigation.
But he did so. Again, I do not understand how you can state that because he mentioned how this affected the family of these two individuals who defendant killed, shooting one in the back twice while the person was crawling on the ground. How, because he mentions that somehow he did not take into consideration the defendant's age. He talks about this in his decision.
I'm not saying he didn't know the age. I'm saying he didn't take into account the fact that children were less culpable, that they're more impulsive. In fact, he also focuses on remorse. Remorse is a character of maturity. In fact, the court in Graham specifically said, maturity can lead to considered reflection, which is the foundation of remorse. So in looking at remorse as a lack of remorse as an aggravating factor, the court is in fact doing what Graham says should be the reverse.
So your argument is because he did not specifically mention these items, the fact that the defendant was 16, he was a child, the fact that the literature, in 1994 that I recall also, there was literature to the effect, statements to the fact that an individual does not become fully developed until 25 to 26. But because he did not specifically mention those things in his decision, that therefore we should send it back for reconsideration?
No, but look how he's talking about what he's focusing on. Remorse, a sign of maturity, which should have been mitigating, becomes aggravating. Retribution, yes, but only retribution, no. The whole point of Miller is to make sure that children, people who commit murder, a murder when they're a child. May I continue, Your Honor?
You may just finish your thought, yes.
Thank you.
First.
What he looked at the crime, very focused a lot on the crime. Miller is about murder. I'm not belittling or minimizing murder. Miller is about murder cases. What the court didn't see and made a mistake in not ordering the hearing is to hear an expert explain how the nature of a child, how this affected his conduct in 1994. And I will continue in my rebuttal.
Okay, you'll have
Thank
2
you.
minutes on rebuttal. Thank you.
Good afternoon, and may it please the court, John Commendoria for the office of Darcel D. Clark. I would just like to point out that with my adversary's claim that the court erred by not allowing an expert for a hearing, at no point from the time where the court asked both parties to submit anything regarding rehabilitation or any evidence of lack of rehabilitation, did defense proffer any information, any statement that they were getting information or evidence, or any proffer of what an expert would have testified about, or that there was any expert analyzing the information. For the first time, that was made in a footnote in the brief. And if I may continue, Jones v. Mississippi does control here. Jones v. Mississippi outright said that a discretionary sentencing scheme is constitutionally necessary and constitutionally sufficient, as Your Honor repeated, and that here where defendant was sentenced under that discretionary scheme, where the court considered his youth and where he wasn't sentenced to life without parole, Miller does not apply, and his sentence does not fall under Miller's purview.
Well, I don't think your adversary was actually arguing that Miller applied, because I think it's kind of clear that Miller is not applicable here. But the statute under which the defendant was sentenced, there was a minimum of 15, the max of 25, right?
Correct, Your Honor.
And so he sentenced him 25 consecutive, is that correct?
Correct.
And that was because he killed 2 individuals. So it's 25 consecutive to the 25.
Yes, that was, and Justice Barrett, who sat at the
trial,
who presided over the trial, the testimony and the crimes committed were heinous. As Your Honor said, one was shot in the back twice, the other one was shot in the back of the head. And this was all of this happened after defendant started an altercation while holding a gun while he was on his way out of the apartment.
Well, but ultimately, as your friend pointed out in her argument, we're talking about murder cases here.
Right.
And that's the genesis of this in Miller, and so the crime is almost necessarily going to be heinous. It's just a matter of degrees, and now it's what effect does the then child's adolescence, undeveloped sense of appreciation for one's actions have on the sentence that he or she should get.
Correct. And if I also may make another point as to Jones v. Mississippi, the majority in Jones v. Mississippi said that under a discretionary scheme, a court that has the ability to consider the youth necessarily will consider the youth when counsel makes an argument regarding the defendant's youth during the sentencing hearing. Here that happened. Here, while conceitedly, while defense attorney was brief, he brought up that he was a child, he was 16 years old, that it was his first arrest, or that it was his first interactions with the criminal justice system, the transient nature of him, or the aberrational nature of it, and the impulsivity of the crime. And then those same arguments were also put into the direct appeal before this court in 1997, when this court upheld that sentence as not an abuse of discretion.
I did not see anything in Justice Barrett's decision that talked about, that relied upon retribution, or that the sentence was based upon any type of retribution. Was there any statement concerning that in his decision?
Absolutely not, Your Honor. What Justice Barrett said he did in his decision was that he took into consideration defendant's youth and lack of criminal history, and then weighed that against the crime, the heinousness of the crime, the effect it had on the family, the lack of remorse, and took a total view of everything going on and arrived at the sentence he arrived
So
at.
should he have looked at the lack of remorse again, given the defendant's age?
In this instance, I believe so, yes. Because when it comes to the 440 that's before this court now, when there was an opportunity to show that there was there was absolutely nothing that indicated any remorse either, and his conduct in prison has also been, for lack of a better word, appalling.
So the bottom line is, however, you do agree that given the fact that this individual will be 66 years of age when he would be eligible for parole, is that tantamount, as your adversary argues, to almost life without parole? Or a sentence without parole? Yeah, life without, a de facto sentence of life without parole.
I don't believe it's a de facto life without parole. It's 50 years to life. It's not 100 years in some of the cases that my adversary does cite. But I would also like to note for the court that before the legislature, which is best poised to deal with sentencing disputes and sort of how to correct harsh sentencing if it was harsh, before the legislature is the Second Look Act, or Second Chance Act, wherein if it's passed, defendants who are serving at least 10 years of a sentence will have the ability to petition a court and to present evidence of rehabilitation to have their sentences reconsidered. That is not the law as it is today. As it is today, unless it's unauthorized by law, illegal as a matter of law, or unconstitutional, a sentence that is started cannot be touched. And so here, the court properly exercised its discretion in denying the motion without a hearing. And thank you, Your Honors.
Thank you. A few quick points. One is in response to the fact that we didn't submit documentation at the time, we were still looking. The reality is, this is something, if you find that that 50 to life is de facto LWOP, then my client was entitled to a Miller hearing.
I'd like to go back to that because this is something that Justice Kapnick and Justice Weber started our argument with, and that is what other evidence, or what in your view does a Miller hearing entail? Is expert evidence required? Is the state required to permit the defendant to put in expert evidence on this point?
All the Miller hearings in the states that I've looked, yes, it's all you have. The family can testify, experts will testify to show the progress in prison. It's not about...
When you talk about the progress in prison, I will state that there were demerits. There were disciplinary proceedings against your client.
But it has to be put in context. Do we look at 1997? Do we look... All these things, I'm not an expert. They are prison experts, and these are people who testify. His family background, how he was affected by his family.
But these things were known to Justice Barrett when he sentenced him in 1994. They were in the pre-sentence report. The pre-sentence report, which was compiled by probation, told Justice Barrett and the attorneys exactly the type of family, background, education, etc.
It didn't.
The
In this
pre-sentence
particular
report
case,
did not include that information.
it was the most bare bones pre-sentence report. I will just say, Your Honor, my client was sentenced in the 20th century to a 20th century based on 20th century science. We were only asking for a Miller hearing. If you believe that the sentencing in this case satisfies Miller, then my client was denied the effective assistance.
First we'd have to find that Miller applies.
That's okay. But if you find that, then, and this is a proper hearing, then my client was denied the effective assistance of counsel. He did nothing. My client will never get out of prison. And if I may quote Miller, though my life it is very important, that Miller does, I'm quoting Justice Kavanaugh, did not impose a formal fact-finding requirement, does not leave states free to sentence a child whose crime reflects transient immaturity to life without parole. And all we wanted, and all we asked this court to do, is to order a hearing. Thank you very much.
Thank you. Thank you both. The next case for argument is Sebro versus Sebro.
Thank you. First of all, I have to apologize to the court if it's hard to hear me. I have a common non-COVID head cold, which I caught from my grandchildren, but...
How do we know it's non-COVID? Did you test?
I did test.
Negative?
And tested negative. No fever, no loss of taste.
Okay. You could be asymptomatic, which is...
Oh, but I did test.
I'm joking.
Okay,
it's
we
fine. We're
appreciate
joking.
that.
We appreciate
Thank you.
it.
Just keep your distance.
Keep the mask on. Yeah, stay away. Keep your mask on.
Okay. Well, may it please the court, my name is Jonathan Stein, and I represent the appellant, Betty Sebrow.
So can I ask you a question? It was a little unclear to me reading the briefs. Does Mrs. Betty Sebrow get the value of the shares even if she doesn't have the right to help run the company, or is she just out cold because?
Well, that's a very good question, Your Honor, because it's not totally clear that she does, even though they've made comments, so she'll get the value of shares. But the one thing she doesn't get control over is what expenses are going to be allocated against those shares. Early on, and this is outside the scope, but prior counsel, who unfortunately passed away, prior counsel for a defendant respondent, was insisting that things not related to Orbis Corporation be paid in order for him to do a deal. It may even be at that point, Your Honor, because taxes have not been paid on this property for a long time, that they may have actually lost the property already.
But counsel, to follow up on that question, she is suing, this is a derivative action, a shareholder derivative action, right?
Mm-hmm.
She is not contesting or in any way arguing that she is not receiving the value. She is arguing that she was not allowed the shares, she's not allowed to take part in any of the corporation's dealings, and she's not being given an accounting. Is that correct?
That's correct, Your Honor. Okay. But on the crux issue, this all rests on the affidavit of defendant Tzvi Sebrow. That affidavit on the jurat, and it's on page 22 of the record, says it was executed in the state of New York, county of New York. But when you turn to see how it was notarized, it's only, the only attestation is by Leanne J. Foreman, attorney at law, state of New Jersey. Now, I don't know where this affidavit was notarized, because it turns out that Ms. Foreman is also an attorney with the firm of Moskowitz and Book, and I know the firm well. So it may have been notarized in Manhattan, and if it was, that's clearly defective because...
But isn't that just an irregularity that could be, fixed up? I mean, is that something that we should throw the whole motion on?
The answer is, it could have been fixed up if they had applied to the court to do so. and I'm sorry, Your Honor. And I would refer the court to the Second Department case in Seidman versus Industrial Recycling Properties, a case that I successfully argued 14 years ago, in which the Appellate Division Second Department, on a commercial foreclosure, threw out the judgment because the affidavit was not properly notarized, even though, in that case, a properly notarized affidavit was put in the reply papers because it had been raised so the answer is, not that it can't be corrected, but it wasn't corrected. Either this was executed in New York, in which case it's not an affidavit at all, or it was done in New Jersey, in which case, under CPLR 2309C, it requires the type of certification, necessary to record a deed in the state of New York. And certainly, this would not be a recordable. There's a certificate of conformity that would have to have accompanied this affidavit, which is totally lacking.
So could we not assume that it was in fact executed in New Jersey? And therefore, if it's executed in New Jersey, then it's fine?
I have no idea where it was executed because they never took the position to explain where it was executed in their reply papers. They just said, well, an attorney in New Jersey has the authority to take signatures. The provision that provides in New Jersey statutes that an attorney can take a signature as a notary is the same provision that provides that a notary public can take a signature in New Jersey. And therefore, since we know that a notary public's signature would require a certificate of conformity, there's no reason to doubt that it would here. And this is on a motion to dismiss, not on a summary judgment motion. It could have been corrected. It wasn't. The court just took it at face value that this is a properly
Well, this goes back to Justice Kaplan's comment. Why would it not just be a mere irregularity, and therefore we could consider it could be considered?
Because there's substantial case law that holds while it's a correctable irregularity, it still has to be corrected, and it wasn't. And that's the fact. It just was never corrected.
Okay. What's the prejudice? Is there any prejudice?
What's the prejudice?
Because of the issue as to whether it was notarized, New Jersey, executed, New York.
May I just conclude by answering the question?
Yes, please, go ahead.
The prejudice is that you get one shot at a motion to dismiss. If your motion to dismiss is denied on this basis, then we proceed through the normal discovery route. I'm not going to go into everything my client believes that why my client believes this was a forged, because it's in the papers, a forged shareholder agreement, or why the issue of the dead man statutes is applicable, because quite frankly, the agreement she was referencing.
All right, well, actually, why don't you deal with that issue on rebuttal about.
That's fine.
Okay, that would be helpful. Thank you very much. Can we hear from opposing counsel? Good afternoon.
Good afternoon, Your Honors.
So, counsel, you must have seen that the affidavit was notarized by an attorney in New Jersey, although the caption stated State of New York. Why not just correct it? Why not just put in papers to correct it?
I understand Your Honor's question. However, my response is twofold. Number one, realistically, I and the firm currently were not counsel at that time. There was predecessor counsel, so I can't exactly answer that on point. However, I would refer the court to point 1 of my brief, which essentially discusses the issue of the affidavit. As this court has already said, number one, these are non-prejudicial defects in form, which were not rejected pursuant to the CPLR, and this court can indeed sua sponte overlook it. But more importantly,
But I guess what counsel was saying is that, or at least partially what he's saying, is this is a motion to dismiss. The court granted the motion to dismiss. It ends the case. So shouldn't there, since a lot of it relies upon the affidavit of your client, shouldn't we at least be assured that that is a valid affidavit before we go and dismiss the case, and that's the end?
I understand Your Honor's question. In response, as I've discussed in point 1, it is indeed a valid affidavit. I cite to a case from 2021 of this court, that that reversed a lower court's rejection of an affidavit for defect in form. And this affidavit of defendant Zvi Seabrow, like the affidavit in the case that I've cited in my brief, says that it's duly sworn. And he alleges and says, by the mere fact that it says that it's duly sworn, pursuant to this court's own ruling in the 2021 case that I cite, this is a valid affidavit. Further, interestingly, in the papers below, counsel conceded that he believed that the affidavit was indeed duly executed in the state of New Jersey. Why? And these are on his own papers, because our client, defendant Zvi Seabrow, and the New Jersey attorney who subscribed on the jurat live not only in the same town of Teaneck, but they live 1 mile apart from each other. He conceded in his papers that he understood, based upon that it was indeed likely executed in the state of New Jersey. And if that's the case, and since she is an attorney duly admitted to practice in New Jersey, she can, therefore, subscribe as taking the oath in the affidavit. What I think is more important in this case is really the heart of the matter, is the stockholders' agreement. This stockholders' agreement, therefore, is the reason why the lower court dispositively ruled that it's documentary evidence that the plaintiff is not a shareholder.
So the same question I asked your adversary. So Mrs. Betty Seabrow loses all rights to anything related to this company because her husband did not sign the correct papers before he passed away?
That's correct, Your Honor.
So she gets nothing?
In her own accord, she sued. She took a strategy of suing in her own name personally, and she has staked out a position in paragraph 18 of the complaint, which is at record 11.4. She states that based upon the shareholder agreement, which conferred ownership of the shares to her husband while he was alive, however, after he died, his shares passed to her. She says that outright in her own name. However, it's clear that the shareholder agreement overrules that. There are only 2 ways that shares can be transferred pursuant to the stockholders agreement. 1, upon unanimous consent of the still holding shareholders.
Which is just your client. That's
which is my client, which we know he doesn't consent.
Right, okay.
Number 2 is testamentary disposition to one's issue.
So counsel, she doesn't get the value of the shares. She would have only gotten the salary for 6 months. I think that's inside the stockholders agreement. That's the only thing she was entitled to?
I would believe so. What Your Honor and Judge Kapnick, I believe, was referring to was an issue that the Court of Appeals addressed in the estate of Riefberg case. And that's where the stockholders agreement was construed as a testimony substitute against which the wife, the widow, can take an elective share. The value of the shares, not the shares. However, here, as I pointed out in my brief, the elective share, the 2-year statute of limitations has expired already prior to the commencement of the instant action.
So, but for the fact that the statute of limitations has expired, she would be entitled to her elective share?
It would seem from Riefberg, from the Court of Appeals, she would have been, had she timely elected, she would have been entitled to an elective share had she so chosen, to the value of the shares. But as I put in my brief, that's a red herring. The statute of limitations, according to EPTL, has expired prior to the commencement of the instant action, and it cannot be revived.
Okay, any further questions? Okay, thank you very much. We'll hear from you, Mr. Stein. Thank you very much, counsel.
Okay, so first of all, one of the things the other side is totally ignoring is the fact that these shares were issued years before the supposed shareholder agreement. And my client was married to her husband years before the shareholder agreement. And the same attorney who purportedly prepared the shareholder agreement, prepared the will, the last will and testament, which left the shares initially to my client, and in the case she predeceased him, to issue.
How did he leave the shares purportedly to her if the shareholder agreement says that's
Well,
not
that's
one
why
of the
we
possibilities?
question the legitimacy of that document. As I said,
But aren't you suing, aren't you bringing this lawsuit as?
we were in possession, my client was in possession of an unsigned shareholder agreement which had substantially different language on these issues. So that's why it was not brought before the court. We were not aware of a shareholder agreement which had these kinds of restrictions, and that's why we question it's very legit.
Wait, you don't have a signed copy of a shareholder's agreement with these provisions in it?
No, other than what they gave us in these papers.
But you brought the lawsuit.
Yes, we had an unsigned shareholder agreement, which we presumed had been signed, which did not contain these restrictions. I'd also point out.
But the signed copy contains the restrictions. Are you saying that his signature is a forgery?
She believes it is.
Wait, I thought that his signature was on the stockholders agreement.
A signature purporting to be his.
Right. So, but you're saying that you don't have a signed copy, but you do have a signed copy. It's just that you're claiming that that's not his signature, right?
We're claiming that's not his signature.
Okay, but it is signed. You're just claiming that's not the signature.
That's
Okay.
correct.
But you're saying when you brought this lawsuit, you only had an unsigned copy that
That's
had
correct.
different provisions than these provisions.
That's correct. I see my time is up. I thank the court for its
Any
indulgence.
further questions? Okay, we'll try to figure this all out. Thank you both very much.
Thank you, and I wish the court well.
Yes, we wish you well, too.
Yeah, feel better.
Yeah, get better. Okay, we're taking you at your word. The next case for oral argument is Tavares versus LIC Development.
May it please the court. Good afternoon.
Good afternoon.
I am Kevin Fitzpatrick from the firm Woodsmith, Henning & Berman. I represent the appellant here, the third-party defendant, Hollins Building Services, Inc. This is a personal injury lawsuit with causes of action of negligence and Labor Law 240.
Right, and so the issue is the indemnification clause, right? And whether it applies to LIC?
Yes, Your Honors. There's two claims against my client, the employer. As the court is well aware, there can only be causes of action against the employer where there is a written agreement which expressly and unambiguously calls for indemnification of a party or a grave injury.
Right, and so this states that it holds harmless Tishman as agent, Tishman solely in its capacity as agent for LIC.
The hold harmless agreement calls for owner's agent, which is defined as Tishman, and the third-party plaintiff here is LIC. So there is no explicit agreement to indemnify LIC, the third-party plaintiff.
Right, it only says Tishman.
That's correct, Your Honor. And the contract goes to great lengths to differentiate where it's certain provisions applying to Tishman or LIC. Even if that hold harmless agreement were to be held applicable to LIC, we argued that it's still not even triggered due to the language in the agreement, which calls for a hold harmless based on claims by tenants or others whose personnel or property may be damaged.
Since Tishman is a party to this solely as an agent for LIC, why then would it not also, I mean, why would Tishman need to be held harmless? Would it not flow that it's LIC that's going to be held harmless?
Well, Your Honor,
I mean, Tishman has nothing to do with anything, right? It has no There's no interactions by Tishman or anything. It's only as an agent. So why would it need to be held harmless from anything?
Well, Tishman, at the time of this motion, was not a party to the lawsuit. But if Tishman were sued, then they would have a hold harmless agreement applicable to them.
But they're only the property manager, right? So, but I'm just curious as to what they would need to be held harmless from as the property manager. It would seem, again, as they're stating that the contract is signed by Tishman solely in its capacity as an agent, it would seem, therefore, that you would want to read this as to state that it's LIC that's going to be held harmless.
There is no language that calls for LIC to be held harmless. The parties did not agree to hold LIC harmless here.
And if they were growing, and if the intent was to hold LIC harmless, then the contract would clearly state, indemnification clause would clearly state LIC to be held harmless.
Exactly, Your Honor. It would have said that because, again, the contract differentiates between the two throughout. So they clearly only intended to have Tishman in this instance. And briefly, Your Honors, the other claim was for common law indemnification. The lower court's decision was silent about that portion of our motion. However, LIC did not oppose dismissal of that claim. They, for the first time on appeal, argued that common law indemnification should stand. There's no grave injury.
Isn't that precluded by the workers' comp law?
Yes, Your Honor.
Grave injury?
Yes, Your Honor. It is precluded because there is no grave injury here. There's no grave injury pled, and the bill of particulars does not assert any grave injury. So those are the only two causes of action, and there can't be a third-party complaint against Collins based on that. Thank you.
Thank you.
Good afternoon, Your Honors. Eric Schlesinger from the Law Offices of Golden Rothschild, Spagnola, Lundell, Boylan, Garubo, and Bell on behalf of defendant, third-party plaintiff, respondent, LIC Group. I will be brief, Your Honor, and I will start off with this case comes before this court on a motion to dismiss under 3211, in which there is an undeveloped record in the trial court below.
Well, sir, what do we need to develop in a situation like this where we're looking at a contract? And if the contract, if it's plain and unambiguous, then aren't we permitted at this procedural juncture to resolve the case?
In normal circumstances, I would agree with Your Honor. However, in this situation, the trial court raised the question in its own decision as to whether or not this contract actually applied, which raises a secondary issue. However, the other aspect that we have here, which may moot these entire proceedings, is the plaintiff in the trial court, or in the case below in the personal injury, just amended its pleadings and named Tishman as a defendant in this case. My office is representing Tishman, and we'll have a motion pending or being prepared to be filed to amend the third-party action to name Tishman as a third-party plaintiff.
Which
So
is interesting, but how does that affect LIC? I mean, that still may not change the situation in terms of LIC. It might help out in terms of getting Tishman in, but how does LIC get in?
Well, the third-party defendant relies upon the Court of Appeals decision in Tonker regarding there is no distinct statement of indemnification with respect to, in that situation, a construction manager who was an agent of the owner. We have the opposite situation here. Here we have an owner's agent acting on behalf of the owner. So the agent is clearly acting on behalf of the principal. So there's clear intent. And if there's not clear intent, it remains a question of fact as to whether or not there is intent. We say Tonker doesn't apply, and that the court has to at least develop the record as to whether or not there's an intention to have LIC indemnified under the terms of this contract.
Why do we even need to look at intent when, again, as my colleague stated, we have the contract in front of us, which clearly states that Tishman, acting as agent for LIC, it only states that Tishman is to be indemnified.
Because LIC is an intended third-party beneficiary of this contract.
But again, there's nothing in the contract which says that LIC would be held harmless.
I agree with Your Honor on that. There's nothing in this contract that says that. But the question becomes whether or not under principal-agent relationship, whether or not the principal intended to ensure that or the agent intended that the principal should be indemnified.
But that has nothing to do with Collins, right? Would that not be between Tishman and LIC? Wouldn't have anything to, Collins would not be a party to that.
Collins would not necessarily be a party to that, but Collins in this case has an obligation to at very least Tishman, and Tishman has an obligation to LIC. At the time this third-party complaint was brought, Tishman was not a party to the case, only LIC was. LIC was acting and said, hey, they belong in this case, there's an indemnity obligation. That's where we're at. The other issue that we have here, and it's a completely minor issue, but, well, I should say not a minor issue, but a secondary issue, and that is the defense that is being asserted by Collins in this case wasn't actually pled. They're seeking dismissal under 3101A, 1 and A7. A7 can be brought at any time. A1 says, because they're relying on a contract, that you have to place the defendant on notice, and they never affirmatively pled that. If you look at the pleadings, which is as part of the record on appeal at pages 105 through 107, they never raised this specific defense as to LIC.
Do you have any objection to the workers, the common law indemnification and the workers' comp argument? I mean, how are you going to oppose that?
Your Honor, I believe that was more of a throw-in argument on the papers since it was initially addressed as part of the moving papers. I will concede that there can be no common law indemnity claim without a grave injury or contribution claim without a grave injury.
And there's not been any okay.
That's correct.
Okay, thank you very much.
Thank you, Your Honor.
Thank you, Your Honors. Briefly, we need...
So what about the fact that they're acting as an agent for a disclosed principal here? Why isn't that a typical third-party beneficiary situation that would require some more looking into rather than just dismissal on the contract?
Your Honor, there is no language in the contract which confers third-party beneficiary status on LIC.
But it says, it clearly states Tishman acting solely as the agent for LIC.
It does, but the indemnification agreement, which courts have routinely found has to be clear and unambiguous, only calls for Tishman, the owner's agent, to be held
So you're
harmless.
saying that it would have to use the term third-party beneficiary in the contract, those words exactly, in order to consider it a an intended third-party beneficiary?
Based on the workers' comp statute and based on case law such as Tonking and the Nicholson case, which we cited, the indemnity provision has to be clear and unambiguous, and here there was simply no intent based on the four corners of the contract to hold LIC harmless. Rather, it was only Tishman. But even if the court were to find that that was applicable, the provision is still not triggered based on the language because the plaintiff is not a tenant and the plaintiff cannot be considered others whose personnel or property was damaged by a contractor. Wouldn't make sense. So this hold harmless provision is not a clear and unambiguous written agreement, which would be the basis of a contractual indemnification claim any way you look at it. Thank you, Your Honors.
Okay, thank you. Thank you both. The next case for argument is People versus Williams.
Good afternoon, Your Honors. Jan Hoth for Appellant Daniel Williams. I'd like to turn immediately to point 2. Mr. Williams absolutely had a right to be present at the hearing held to determine if he should undergo a psychiatric examination.
You refer to this as a hearing. I did not see anything in the record that I would characterize this as having been a hearing.
Well, it certainly wasn't called a hearing, and as my adversary points out, the court did not invite argument. Nevertheless, the court entertained argument.
Did the court actually entertain argument? You know, from reading the transcript, I also noticed that at some point in time, apparently the court had directed that this be off the record. And for whatever reason, it continued to be transcribed. But did the court actually invite argument? The court stated, according to the transcript, the judge stated, I'm going to order a psychiatric examination. She didn't then say, what are your feelings on this? It was after the defendant had been removed from the courtroom because he had been agitated during his testimony, and there was some concern, and so they asked that he be escorted from the courtroom so that he could calm down, for want of a better word. But, and then at that point in time, she says, I'm going to, based upon his behavior, I'm going to order a psychiatric examination. She didn't then say, you know, attorneys or, you know, does anyone have any statements or anything to say about that? It was the prosecutor who then made a statement.
Right, but the court doesn't have to invite the argument for there to be argument. The district attorney objected to the psychiatric examination, but didn't just limit her comment to, I object, nor did the court limit its response, well, I assume that would be your position.
So my core issue, my core question is, was this actually a proceeding or was it ancillary to the actual proceeding wherein the defendant would actually have to be present?
Well, what we haven't gotten to is the remainder of what happened. The court responded to the district attorney's suggestion that objection, and then statements that he seemed to understand the proceedings, he was making good arguments, he needed time to calm down. And the court said, well, I'm concerned, the defense is so paranoid. And then the district attorney started referring to the grand jury testimony. And then the court said, let's go off the record. And we have no idea what happened there. All we know is at the end of that off-the-record discussion, the court had changed its mind.
No, the court said it was going to consider it over the weekend, I think, or said, you know, I'll think about it. Did not make a determination one way or the other. And then, because that was Friday afternoon. And so now Monday, there's absolutely no mention of it whatsoever.
But the court,
to the extent that no psychiatric examination was ordered.
But the court started this with she was going to order it and she wanted it done over the weekend.
And then in response to statements from the district attorney, the court reviewed the grand jury minutes, and that's when it went off the record, after she said, let me see the grand jury minutes?
Yes, and then when the court heard that there was grand jury minutes, they go off the record, and whatever conversation is had, then the court comes back and says nothing, calls the defendant back in, doesn't even have the courtesy of telling him what happened in his absence.
Oh, that's interesting. So here's a defendant who's pro se, who has been agitated, who apparently has been, according to the record, jumping up and down and is, you know, not being calm. So the court at that point in time should have brought him back into the courtroom and say, you know what, I think you need a psychiatric examination?
Well, the court brought him back into the courtroom, and the court explained again about proper behavior, et cetera. If the court wanted to protect itself and make it clear, it should have said to him, you know, while you were gone, we discussed whether you should undergo a psychiatric examination.
And you don't think this would have caused him to become even more agitated?
Well,
or that should not have been a concern of the court?
But he had if he did, then the court had the right to do what it did at the very next court appearance.
I guess my bottom line is, or what I do not understand is, what was the harm? I mean, because also the cases talk about whether, you know, one of the reasons why the defendant should be present, et cetera, because he or she should be aware of what's going on. Also, so that they can have input and so they can input and impact the case and how it proceeds. She did not order the psychiatric examination. So I'm not really clear as how is this a negative impact, or how did this negatively impact upon the defendant in his right to a fair trial?
Considering we have no idea what the court based its change of mind on since it's off the record.
How is that relevant?
It's all relevant. The defendant is representing himself. This should not be being conducted without an advocate for him.
But the reason we don't have a record or an idea as to what she based her decision on is not because he was not present. Apparently, it's because it wasn't transcribed.
She said, let's go off the record. It wasn't simply not transcribed.
Okay, because she went off the record. So is your argument, therefore, I would think should not really be that he should have been present, because even if he's present and she goes off the record, we wouldn't know.
But who knows better whether what his psychiatric problems may or may not have been, what his medication was. Standby counsel had 1-year-old records, didn't know what he was taking.
So your argument, therefore, is that if the court had said to him, Mr. Williams, I'm thinking of ordering a psychiatric examination, what's your opinion? That he's going to say, yes, please, I need a psychiatric examination?
But you're putting the cart before the horse. We can't excuse his absence, either as a defendant or as pro se counsel, simply because now, hindsight being 2020, we think the outcome was favorable to him. We don't know if the outcome was favorable to him. I think he'd disagree, because on Monday, the court terminated his right to represent himself, something he had begged for, demanded, and did.
So your argument is that there should have been a psychiatric examination, or at least he should have had input as to whether there should have been one, and then if he agreed to it,
What I'm saying is he had the right to be present. These things should not have been discussed and decided in his absence. He was not just the defendant, he was also the attorney. Had counsel been kept out of this hearing, I don't know that we'd be arguing about whether the outcome was favorable or not. He clearly had a right to be there. Counsel had a right to be there, so defendant had a right to be there.
Okay, you'll have a few minutes. Thank you for answering,
Your Honor, I'd just like to point out that I might go to point 3 on rebuttal.
Whatever.
I want my adversary to know.
Okay, thank you very much, Ms. Huff.
May it please the court, Karen Schlossberg on behalf of the people of the state of New York.
Counsel, I just want to just clear up about the progress of this proceeding or not proceeding or whatever it is. At some point, the defendant became agitated, right? And then the court said she was going to order a psychiatric evaluation. Then the defense counsel made some statement about he didn't know if he had medication. And then the people started talking about that they didn't know if a psychiatric examination is necessary. And then the court responded, she went back and forth, maybe she's not going to do it. But then the people again continued to talk about the grand jury minutes to the point where the judge said, let me look at the grand jury minutes. Even if we're going to debate the issue about the psychiatric issue, when the people started mentioning the grand jury minutes, why wouldn't the defendant have the right to be present at that point?
Why would he, Your Honor? I mean,
because he was the pro se counsel.
He was pro se counsel. I'm sorry, I don't mean to interrupt you.
No, go ahead.
I would just say, first of all, I would say standing counsel was there, standby counsel. It wasn't as though there was no one in the room with defendant's interest in mind.
But the defendant was pro se.
Correct.
The counsel was standby.
Correct.
By definition, he was not the main attorney. The defendant was pro se.
I agree with that. I just wanted to point that out because it hadn't been mentioned. I don't know why the judge wanted to see the grand jury minutes. I don't really understand.
Well, because the people suggested it, right? The people started talking about the grand jury minutes, and then the judge said, let me see the grand jury minutes.
The judge was very concerned about the defendant's level of agitation, and the prosecutor said he had said something different at the grand jury, so the judge wanted to look at it. I think that's not, I understand what Your Honor is asking me, but I don't think that is the core question here. I think the core question here is, what happened at this proceeding. And the way my adversary is representing it, it's as though there was a question on the table and it was decided in defendant's absence. And that is just, I think, not a fair reading at all of what happened. If you look at the record, it's 2 pages in the record. It's 406 and 407, essentially, of the transcript. And what the judge, yes, the judge immediately says she's exasperated. The way I read it, she's exasperated. She says, I'm going to get a psychiatric evaluation. But then, right after that, and not in response to any argument, she's saying, I don't know how I'm supposed to proceed in a situation like this. This is on page 406. He's shooting himself in the foot. He's making a spectacle of himself.
Are you going to skip over what happened on page 405 when the people started
Not
their
at all.
argument?
I don't mean to skim over it at all. I'm just trying to say that my point is just that even after that, Your Honor, she's not making any decision here. This is not a proceeding in which the judge is hearing argument and making a decision. I just want to say, she says, I'm going to do research on this and make a decision. And then she says, I think it's incumbent upon me to take a pause and figure out the best way to proceed. And the next thing she says is, I'm going to bring the defendant out and speak to him. And she does. She brings the defendant out.
Again, you're skipping.
When she brings the defendant out to speak to him, she doesn't then say, you know what, we were discussing whether you need a psychiatric examination.
Correct, but she asks him, if you look at the questions that she does ask him, they're all about whether or not he understands what's happening and he understands what's going on. That is what she's doing. And I first of all, don't think she was ever questioning his ability to proceed. I think she was concerned about something else. I think she was concerned about his agitation level and what she said, that he's shooting himself in the foot. I don't even think my adversary thinks there's any basis in the record to think that this defendant didn't understand the nature of the proceedings. I think the judge was upset. She was concerned that he was hurting himself. She wondered if she needed to do something to protect him. She clearly wasn't talking about a 7:30 examination. Those don't happen over the course of a weekend. That's a whole procedure.
Well,
So I think
she doesn't refer to it as a 7:30. She refers to it as a psychiatric examination.
I think she.
But the right of a pro se defendant to be present is a core principle. So as your adversary says, given the fact that it's a core principle, do we just kind of ignore it under these circumstances because in hindsight, the ultimate lack of a decision, I guess, was beneficial to the defendant?
I'm sorry to interrupt you. I didn't mean to.
It's okay.
He doesn't have a right to be present for every single exchange and every single colloquy. Even a pro se defendant representing himself does not have a right to be present for everything. He has a right to be present at material stages, and if he's acting as
So that's the question. So
for a
that's why
critical
when your
stage.
adversary began her argument, she referred to it as a hearing. And that's why I asked whether you would characterize it as a hearing. So is this a material stage in the proceedings?
Definitely not. And there are cases that I cited in my brief where, either a pro se defendant was not present for an exchange, or a represented defendant didn't have his counsel present. So you're talking about both a defendant's right to be present and also the right to counsel, whether counsel should be there. And in both situations, it's not that they're entitled to be there for every conversation between a judge and someone in the courtroom. It has to be something that matters, something that affects the defendant's due process rights, something that is in both situations, whether even for counsel to be present, to be required to be present, it has to be a situation, a critical stage of the proceedings where a defendant's rights are at stake. Nothing here happened of consequence. The defendant was brought back in the room within minutes. I'm assuming it's minutes because it's 2 pages. He's brought back in the room. The judge talks to him. They talk about how it's going to proceed. And she probably goes on to do what she said she was going to do, which was do research about how she should engage to protect his rights. And what she would have learned is that there was nothing that he had done so far that required her to do anything or that she should do anything. I see that my light is on. If I could just make one more thing, because I'm not going to get into the next point.
One more.
I'm not going to get into the next point. I just think that anybody reading this trial transcript, the one thing that screams from the record is that Justice Scherzer did everything in her power to protect this defendant's rights. And he made it hard. But she was bending over backwards throughout this entire trial to do whatever she thought was the best and fairest thing for him. This colloquy did not deprive him of any rights, and he was not deprived of his right to be there or to have counsel present. Thank you so much.
Thank you, counsel.
I'll just respond to that. Everybody seems to be working under the assumption that the fact that no psychiatric examination was ordered means that who cares if the defendant was there? Except Tellingly, when everybody comes back on Monday and Mr. Williams takes the stand, within 15 transcript pages, he's abruptly told, you can no longer represent yourself. There's a very strong suggestion here that what happened at that off-the-record colloquy was they figured out another way. Yes, Mr. Williams did not make this trial easy, and the judge was a paragon of patience.
That's a separate argument, counsel, in terms of, that's pure speculation as to what occurred in that off-the-record colloquy or discussion.
Yes,
I don't know what happened, and I don't know that you can make that jump, given the fact that Friday, when he testified, he was also agitated. So now he comes back on Monday and he's still agitated. So I'm not sure that you can actually make that jump. But
well,
you said you were going on to the
I'm
third.
making the suggestion, Your Honor, that it highlights why his presence was necessary.
And I'm just saying that I don't see a correlation between his presence and his not being present with what happened during that off-the-record
Because perhaps during whatever happened, perhaps the judge would have determined that, yes, in fact, even with his information, maybe there's information that she did need to order this exam. Maybe things did need to stop.
So what was your the third issue?
The third point had to do with juror number 2 and whether or not he could be fair and impartial. And I would just like to very briefly point out that as the prosecutor argued below, if you look at the initial comments of juror number 2, he made it perfectly clear that he could not be fair.
Didn't the defendants want to keep this person on the jury?
The defense counsel initially argued that he did not believe that juror number 2 had said he could not be fair and impartial. I think the record proves otherwise. The prosecutor argued otherwise.
Well, again, the record indicates that the defense attorney made it clear that if juror number 2 were removed, it would be over the defense objection.
The court has the authority to discharge a juror if that juror is
grossly unqualified.
And here, the juror was saying repeatedly, he wasn't saying I can't be fair. No, he was saying, and what happened is in the very beginning when he called the clerk, he said things were said that concerned him.
Right, and then when he comes to court, 11:15 or 11:20 a.m., when he finally gets to the court, he's questioned.
Correct.
And he states that he can't go into what happened during deliberations, and you cannot do so, right? You can't inquire. Counsel wants to inquire as to what occurred during deliberations. The court says, no, you can't do that. And then they go on to whether or not he can be fair and impartial. First he says, no, I'm not sure. Then he says yes, right?
He never said he could be fair and impartial.
Counsel wanted to have him to release, the court said, well, I will discharge him. And the attorney says no.
Well, the attorney wanted further inquiry. The attorney also said, I didn't think he said he couldn't be fair and impartial. The prosecutor said, yes, he did. The court has to make a decision.
But at that point in time,
defense counsel doesn't make the decision.
Counsel, at 576 and 577 of the transcript, the court asked defense counsel for his position as to this juror. And the defense counsel says that he wants deliberations to continue with that juror. The court then responds that the juror said that he can't deliberate, which means that the juror can't be fair. But defense counsel responds that he disagrees with the court.
The court itself said that it believed that the juror's responses, I can't continue, indicated his inability to be fair and impartial. She then said, but I'm not doing this over the defense objection. That makes no sense. That is her job.
So your argument is now that the court should have discharged that juror over the defense objection.
If not made further inquiry.
But there was no further inquiry to be made because the juror said that he could not talk about he would be precluded from speaking about what went on during deliberation?
Well, I think there's a separate argument as to whether or not the court had the authority to question the juror.
I find it interesting because if the court had discharged the juror, you would have been here arguing that the court shouldn't have discharged the juror over the defense objection. And now you're here arguing that the court should have discharged the juror over the defense
I'm
objection.
arguing that the court should have, my argument is not much different than the prosecutor defending what the judge did, despite the trial prosecutor insisting the juror should have been discharged. The point was the court was abdicating its responsibility. It's not gamesmanship. It's the court had the authority to discharge that juror over the defense objection if he couldn't be fair and impartial. The court believed he could not be fair and impartial, said it on the record.
So defendants should have joined the request then for the, further probing inquiry, as opposed to getting the juror, instead of getting the juror you want, the verdict not coming down the way you want, and now coming in and pressing that a further inquiry should have occurred.
Possibly. Remember, at this point, standby counsel is now representing the defendant. We don't know. I mean, it's not Mr. Williams anymore. So
I don't understand the
defense
point.
counsel's making arguments because the court is saying, I'm not doing it over the defendant's objection. But we don't know what Mr. Williams wanted.
Mr. Williams wanted that juror. He stated from jury selection that he wanted that juror. That juror was helpful to him because the complainant had misidentified the juror as the person who robbed him. Everybody, the defense wanted that juror.
But that doesn't mean the defense wanted the juror, but the court's responsibility to decide whether the juror can be fair and impartial.
Yes.
Okay. And again, saying that now because they rendered a verdict of guilty, the defense is supposed to say, well, no, the court abdicating its responsibility is irrelevant.
Okay. I think we got the point.
Thank you.
Thank you both very much. The next case for argument is Jackson versus Hunter Roberts. Good afternoon. You may proceed.
Good afternoon, Your Honor. Stephen Kalina, Cox, Padmore, Skolnick, Shikarchi for the plaintiff appellant. Good afternoon. Your Honor, I'd just like to make three brief points regarding the errors made at the motion court below. The first is that the motion court narrowly confined itself to a means and methods analysis, and this is not a means and methods case.
So do we have some cases that said it may be a combination of a means and methods and a defective condition?
There are cases that we submitted that are first cited, and I think in the Capabianca case, I think it's the employer mutual case and the Wofford case, that a condition, and we're not saying that this is a means and methods case, but to answer Your Honor's question directly, that at a certain point, if a condition, which is part of the work, still is extant on the job site, it can become part of the, can become a condition of the job site and be a dangerous condition on which liability can attach to the general contractor or the owner.
So what was the testimony, the record, or the record, what does the record show in terms of when this plywood walkway, or whatever you want to call it, this path, when was it first put down? Do we know?
Our client testified that he saw it on the first day of his work. The record reflects the fact that he filed an accident report prior to the accident date of 2009. He filed that in 2008. So we know that he saw the ramp for at least 2 months. If you look at both the client's, my client's rather, affidavit.
So this wasn't something that was recent, right? This was not something that was recent.
Yes, Your Honor.
Something that had
It was
existed for a while.
Not to speak over, yes, it was not recent, for it was at least 2 months, so we can establish from the facts of the record. And that's a critical point, because this condition, which is there for at least 2 months, is, as the court says, a makeshift plywood ramp that traverses a decline of 6 to 10 inches. On one end rests on loose dirt, on the other side cement. And it bowed under the weight of the person, two persons that were on it, and significantly did so without debris or other wet conditions. And that, Your Honors, places this condition akin to the Torkel case, which was an unbraced ramp, and not the Villanueva, the elevator issue in the Villanueva case on which the defendant respondent rests. There was no manipulation here of, in that case, the elevator. Here, the condition literally was laying on the ground as part of the job site.
Sir, what's the standard or test we use to ascertain whether an action arises as a result of methods and means?
Whether the, Your Honor, whether it's an instrumentality, whether it's a tool of the work, whether it's part of how the plaintiff was performing his or her work. And here, the testimony is that pipe was being simply carried from a loading zone into the garage to do the work.
And there was no other way to go other than over this makeshift ramp?
I believe the record reflects that this was the only way to do so. And this was, Your Honor, an entranceway into the garage for pedestrian use. Our client testified that, and it's very important to recall, that he was not directed to use the ramp, which would go to Your Honor's question, what would be the standard, the means and methods? So his foreman didn't say, you must use the ramp that I laid down for you. In fact, the record isn't even clear that the subcontractor laid down the ramp, as to Your Honor's question about standard. The testimony in the record, both from the plaintiff's perspective and the defendant's perspective, is nobody knows who put the ramp down, which takes out, on some level, the means and methods analysis. Had it able to been established in the record, and this is motion for summary judgment, that the subcontractor laid it down, then, to Your Honor's question, you could begin the analysis, which the Supreme Court did errantly, that this is a means and methods case. But there is no such testimony in the record. Which brings us then to constructive notice, which an issue that the court also, my second point, decided incorrectly, because this condition laid 30 feet from the site supervisor's trailer, who testified without any dispute that he could see the site where the accident occurred. That our client, as mentioned earlier...
But he didn't specifically say he could see the ramp or that he was...
No, that's correct, Your Honor. I'm just saying the area in which...
Right, I understand.
Could see it. I see that my light is on, so I'll answer any questions the court may have.
You have 2 minutes for rebuttal, so let's hear from opposing counsel.
Thank you,
Thank
Your
you very much.
Good afternoon, Your Honors. May it please the court. Adrian Yaron, Cullen and Zeichman for respondents.
So is there anything in the record as to who laid down this ramp? Was there anything stating that plaintiff's employer, J.M. Botto, laid it down?
I'm so glad you asked that, Your Honor. In fact, plaintiff's counsel admitted and conceded before this very court at oral argument on the last appeal in this case that the employer, J.M. Botto, laid down the piece of plywood. Also, there's an affidavit from this non-party site safety super, Mr. Curry, that the ramp was put there by the employer.
And the ramp was put there by the employer. This was the original ramp, original for want of a better word, but this was the same ramp that was put down by the employer months prior to the incident?
Your Honor, I'd like to actually bring us back to that question. The only evidence that this was there months prior is a feigned, belated affidavit submitted by plaintiff 6 years after his deposition, 10 years after the accident, and after this court dismissed his labor law claims on the last appeal. Everyone else in this case testified there was no ramp there. There was no piece of plywood there. We have the site safety supervisor and the senior super of the site testified they walked through that area all the time, never saw a piece of plywood there.
How did they get back and forth if the testimony, there was testimony that there was a height differential in order to get from where they unloaded the pipe to where they were taking it in, they had to walk across something. So what was...
Your Honor, it's a driveway. There's actually a wide wide space there, it's a driveway, it's a small difference, few inches. People just walked there. And for that matter, there was no reason to use this piece of plywood. They could have simply walked across the path. One of the witnesses testified there was only 2 inches difference. So there's a different, however big it wasn't such a big step. They could have simply walked it across. And that's where Villanova actually is on point here. In Villanova, the reason it was means and methods is because the workers in that case were carrying a 500-pound steel beam and chose to use an elevator that wasn't made to carry that kind of weight. Same thing here. These guys were carrying a 200-pound bar, pipe, whatever it was, and chose to walk on the piece of plywood instead of just walking across and putting it down on the cart.
Okay, let me just ask you, I'm looking back at the decision from 2018 and the prior appeal on this case, and it specifically says that the height differential of 6 to 8 inches mediated by the ramp did not constitute a physically significant elevation differential covered by the statute. That was why they dismissed the 241 claim. But nonetheless, there is a recognition in our prior decision that there was a height differential that was mediated by a ramp. So the ramp didn't just show up today, it was there 4 years ago, just under 241, that wasn't, the court dismissed it.
Again, Your Honor, in that case and in the oral argument on that case, it was pointed out at that point that the ramp is part of the plant and the equipment provided by the employer. And that is a classic means and methods case under black letter law. But means and methods isn't just how you do the work, it's all of the tools and equipment that are provided by the subcontractor.
The ramp was serving as a passageway. So I mean, they needed the ramp to serve as a passageway, so why if there was a problem with the ramp, why couldn't that also have potentially been a problem with the condition, the premises, a dangerous condition on the premises? They needed to use the ramp, everybody was using the ramp, he fell on the ramp, maybe that's not what caused it, but isn't that at least go into the value analysis?
Your Honor, there's no testimony that they needed to use the ramp. They chose to use the ramp. Nobody told them to use the ramp. They just decided to use it. There was clear space on either side of the ramp. They could have simply walked across. By the way, I want to address Torkel briefly.
Wasn't the ramp covering a ditch?
Sorry?
Wasn't the ramp covering a ditch?
It wasn't a ditch. It was simply a slight differential between the paved area and the non-paved area.
Yeah, it says a height differential of 6 to 10 inches, but if you're carrying a heavy pipe, maybe you don't want to start jumping over a height differential. So maybe using the ramp made some sense. I mean, I'm not trying the case, but these are, these are all the issues that have been raised.
Again, Your Honor, maybe it made sense to plaintiff, but again, it's plaintiff's choice to do his work in that fashion. And by the way, in Torkel, if I could just briefly, has nothing to do with this case. This court was not asked to decide whether it was means and methods or condition in Torkel. And in fact, in that case, the court found the GC, there was evidence that it had both control and had placed a piece of plywood in Torkel. So it's a completely different case.
Okay, thank you very much.
Thank you, Your Honors.
So counsel, does it matter if in fact the employer, J.M. Botto, admitted that, or in the prior proceedings, it was admitted that they put down the ramp?
Well, Your Honor, the predicate of your question we would submit is incorrect, that they don't admit that they put it down. And I can walk Your Honor through that, if I may.
No, but is your adversary correct that that was conceded, or at least that was stated in the prior case?
Just to understand Your Honor's question, it was conceded that J.M. Botto put the ramp down? Is that the question?
Yes.
Okay. The answer to that question, Your Honor, is no, and I can take Your Honor through that ever so briefly. Okay. In May 2015, in this record, Mr. Cleary, who's the site safety supervisor, signs an affidavit that says, quote, all tools and materials used and provided to J.M. Botto, including the plywood utilized in the makeshift ramp, were provided by J.M. Botto. That's 2015. The appeal transcript in 2018, in which the court relies on a statement establishing that the ramp was somehow provided by Botto, and that's at record page 1081. But in the June deposition of Mr. Cleary in 2018, which post-states the transcript on appeal, at his deposition, we would submit Mr. Cleary walks back his affidavit stating, quote, if there's a ramp or anything like this, the material would be provided by the contractor. In fact, Mr. Cleary testified that he could not recall if he ever observed the ramp prior to the accident. He also stated that at that particular location, which he passed since it was next to his trailer, he didn't see any ramp. Mr. Cleary walked back the fact in his testimony after the appeal that I didn't see it, and if it was there, it would have been. No one conceded then or after that in fact the subcontractor put it down. And therefore, when the trial court said this is a means and methods case, to Your Honor's question, and went down that analysis, it was errant. The dangerous condition, constructive notice was established. This is a readily observable site, and we would submit that the trial motion court errantly decided this case for summary judgment in favor of the defendant, given the issues of fact. And I would just like to add one point on, my red light is on, that the court readily accepted Mr. Cleary's testimony, which I just refuted, and did not accept Mr. Jackson's testimony, and issues of credibility are beyond the scope of summary judgment determination. We would submit that the motion was incorrectly decided and should be reversed.
Thank you. Thank you both very much. The last case for argument is Kurland and Associates versus Glassdoor.
Quick procedural question. Do you have a preference as to which appellant goes first, the plaintiff or the first filed?
Who was the first filed?
It was the defendant. I don't have a preference. I'm just asking.
Well, if, I would have thought it would be the plaintiff, but if you're the first one that filed your appeal, then I guess go ahead. Counsel, do you have any problem with that?
No problem with that.
Okay, thank you very much. You know what? It doesn't. You don't have to move your seats, really. We'll figure it out, right? You're going first. We know that, and you're the only ones here, so it's right. It's quite all right. Thank you both.
It's late in the day.
I get it.
Good afternoon. May it please the court, my name is Michael Hensley. I'm with the law firm of Bressler, Amory, and Ross, and I represent the appellant defendants, cross-respondents, Glassdoor, Miss Shooter, and John and Jane Doe. This is a dispute as to which standard should be applied to our trial court motion to dismiss. As we contend, we believe it's 3211G in the anti-SLAPP statute, or as the plaintiff contends, 3211A7, a failure to state a cause of action.
Now, isn't the problem that there was no 3211G at that point?
Exactly, you're right, Your Honor. The only present application before this court on the notice of motion was the anti-SLAPP, the 3211A7. And I'm going to make an argument as to why I think that statute applies. However, even plaintiff's counsel notes in their appellate brief on page 27 that in the event the anti-SLAPP statute doesn't apply, the appropriate analysis would be to look at our papers under 3211A7. And what the trial court clearly found was that none of the plaintiff's claims failed to state a cause of action. They all failed. And whether it's under 3211G, the anti-SLAPP, or 3211A7, this case cannot continue under any standard. And that's because, as a matter of law, under New York law and the First Amendment, this poster had the right to speak. They had the right to voice their opinions about the working conditions at the Kurland Associates law firm. And they had that right to speak and voice their opinions and give an unflattering opinion.
Counsel, should we give any weight to the offer letter and the salary scale that was established by the law firm? And I'm speaking specifically to the difference between the attorney fellow and the what the defendant represented on the website.
Yeah, I suggest it's completely irrelevant, Your Honor, because whether someone's a law fellow or an associate, that can't be defamatory as a matter of law. Even the $1,000 payment that was put forth in the third amended complaint is not defamatory as a matter of law. And the court talked about that when they not only dismissed the second amended complaint, but they dismissed the third amended complaint. So we have to take a step back and look at the context of the review.
But we're not, the third amended complaint is not the order that's on appeal here today is not the one that dealt with the third amended complaint, am I right?
Well, I disagree with that because this order today clearly states that whatever, the third amendment complaint was already filed once this motion.
Yeah, but didn't the judge make a decision about the third amended complaint some other time after the order that's on appeal right now?
No, absolutely not. In fact, this court said whatever complaint is the latest.
That's what Judge Engoron said, not us.
Exactly. And then what happened was that after Judge Engoron made his decision, dismissed the case, plaintiff made a cross motion to hold us in default for not responding. We then made an application to say, hold on, why are there more motion practices here? The case is over. We want clarification that when you said you're dismissing whatever complaint is the latest, it included the third amended complaint. And Judge Engoron said yes, and that's when he issued that next order saying, yes, that was included.
But that order isn't part of this appeal, is it?
It is, but it doesn't necessarily have to be, Judge, because what is being appealed is from his order that clearly states whatever complaint is the latest.
He said whatever complaint is the current one, and the one that is the current one would be the second amended complaint and not the third.
The third amended complaint was already filed at that time.
But wasn't it filed without leave of court? So it was improperly filed, and it wasn't really before the court.
Well, and in addition to that, a court is allowed, and we cite case law that says we don't have to file a new motion to dismiss the third amended complaint. We're allowed to rely upon the motion to dismiss the second amended complaint if the facts are the same predicate facts. And here they clearly are. The third amended complaint, all it did was to regurgitate every cause of action based upon the review itself.
So was it your understanding that he was dealing with the second amended complaint or the third amended complaint?
Both.
Okay.
And he says that right in his opinion. He deals with both.
Sorry.
And I know my light is on already, so
I'm sorry.
No, the white light, you still get 2 minutes. That's why I explained it.
Oh, I know.
You have a minute, 18 seconds, so go right ahead.
Under either standard, whether it's the anti-SLAPP or the failure to state a cause of action, this case cannot continue as a matter of law. But what I want to touch on is retroactivity, because we had a curveball. And after we filed our papers, there was a decision in Gottwald as well as Riley that came out and said that it's not retroactive.
Right.
But your honors do not have to get into the retroactive analysis in this case. Keep in mind that the third-party complaint was filed 6 months after the enactment of the amendments. So we have a third-party complaint filed in April of 2021. No case that I'm aware of, and we researched it, has held that if a pleading is an amended pleading, it's a new lawsuit asserting new claims, asserting new parties, Ms. Shooter, that somehow we couldn't apply a currently enacted statute that was 6 months old at that time. So although we have many arguments to make about why retroactivity applied and why we respectfully disagree with the prior First Department panels, you don't even need to get there, because this is not a retroactivity analysis. The third-party complaint was filed after the enactment of the statutes. Further on retroactivity, plaintiffs have not appealed that issue. There's nothing perfected in their appeal on retroactivity. And with all respect, Gottwald did not address the explicit language of the statute that says it can be retroactive. Specifically, if I may just finish this one point, Your Honor.
Go ahead, finish.
Specifically, Section 70A says this statute applies to actions that are, quote, commenced or continued. Well, if it's not commenced, continued means it was already filed. So this is not a situation where we have a lawsuit that was been a stipulation of discontinuance with prejudice. It's over before the enactment of the statutes, and then someone's filing a counterclaim for damages. Here, this case was continued, but Your Honors don't even need to get there.
Okay, you'll have a couple minutes for rebuttal. We'll hear from opposing counsel. Oops.
Good afternoon. Thank you, Your Honors. Yetta Kurland on behalf of the Kurland Group. I want to address the numerous misstatements made by counsel, but first let me just start by saying this is not about First Amendment expression, because defamation is not protected under the First Amendment. This is a case about a small LGBTQ-based law firm who's been the target of animus, who seeks to have untruthful and hurtful statements made about it removed from a large social media site, Glassdoor. That has ensued, given Glassdoor's retaliatory response to these efforts, this case is also about holding big social sites like Glassdoor responsible when they violate their terms of use and allow users to misuse its platform. But before I respond, I just want to say, as an initial matter, defendants offer no basis to justify the extraordinary relief that they are asking for here, namely that this court ignore stare decisis and reverse itself in its unanimous decision issued in the Gottwald decision just weeks ago, after this court thoughtfully and fully considered and decided the issue of whether the new SLAPP provisions can apply retroactively. The court properly found the new amendments to SLAPP cannot apply retroactively as a matter of statutory interpretation and as a matter of law. And just to address the 3 points that Mr. Hensley made with regards to the issue in Gottwald, as an initial matter, the idea that retroactivity wouldn't apply here because we filed an third amended complaint is just, there's just no basis to that. In fact, the Gottwald decision, the cross-claim was filed after the 2020 amendments as well. It's the same index number. Of course, they found nothing about that because it is the same action, and the complaint being amended doesn't change that. Moreover, the complaint wasn't filed incorrectly. Under 3205A, as of right, we had a right to amend our complaint because defendants answered the second amended complaint. We have a right to amend to a third amended complaint, which they then moved to dismiss. Because they moved to dismiss.
But didn't you need leave to file the third amended complaint? You can't just keep, adding amended complaints without leave of court unless it fits within the, certain amount of time or whatever. You just can't do it.
Under CPLR 3205A, as of right, a party has a right to amend its complaint within 20 days after an answer is served, and that's what we did. Then defendants.
But that's one time, right?
That is correct.
Okay, so that maybe got you to the second amended complaint. How'd you get to the third amended complaint?
No, the second amended complaint was because defendants removed it to federal court and we were required to amend the complaint because it was in federal court. This is the only time we used 3205A. It was done properly. The court conceded it was done properly, and defendants filed opposition to that in terms of, pardon me, they filed a motion to dismiss the third amended complaint, which then makes moot the second amended complaint, which, as Your Honor is correct, this decision by Justice Engoron is only addressing the second amended complaint. And the idea that the very ambiguous language about whatever complaint is before us, as the court has mentioned, is the second amended complaint. So while the second amended complaint is perhaps dismissed in this decision, the third amended complaint certainly is not, and that is further established because.
Wait, the third amended complaint would then only have breach of the duty of loyalty?
Breach of duty of loyalty and defamation.
But if we dismiss it, but the defamation was dismissed in the second amended complaint.
It was, Your Honor. However, we submit, first of all, I just want to.
So I'm just trying to understand. So if we upheld the dismissal of the second amended complaint, right, then you would just be left with, arguably, the third amended complaint with the breach of duty of loyalty claim.
That is correct, Your Honor. That is correct. But I just want to make the point because it is very important that this court hold the doctrine of stare decisis as primary to the process of this matter and all matters before the court. And the idea that the court should ignore the decision in Gottwald because this matter had an amended complaint subsequent to its filing is just not founded on law. It's not what retroactivity requires. That was never raised, by the way, in defendant's brief. And the other argument that we didn't raise retroactivity is patently false as well. As we note in our papers, there was not a record kept during oral argument for some reason. So we followed up on March 3rd, docket number 141. We wrote a letter to the court summarizing and restating our position on retroactivity, raising it as an affirmative defense. And if you look at that, we specifically say, pardon me, we say that retroactivity does apply, and we even cite the Majewski matter with regards to that, and the Gleason matter. So we say plaintiff provides here the case citation that relied on an oral argument in arguing that defendants have moved under an inapplicable version of anti-SLAPP because the plaintiff failed to prove that the plaintiffs intended to prevent the SLAPP freedom of information claims, but because also November 2020 amendments to the statute cannot be applied retroactively to plaintiff's initiation of this lawsuit years prior.
Counsel, how do you address the immunity afforded to Glassdoor by the Communications Decency Act?
Thank you, Your Honor. As it makes clear, the cases that both defendants and plaintiffs cite, CDA immunity only applies to those parties who, like Facebook, for example, remain just a neutral publisher. They do not get involved. Here, defendants are seeking the protections of SLAPP. SLAPP is a statute specifically to protect the expression of opinions and views and editorializing. Glassdoor has clearly stepped across the bound of simply being a publisher and been involved in the actual dispute itself. So it cannot both take part in editorializing and also claim it's just an immune third party. To that end, we talk about the badge that Glassdoor posted on the website when we're just trying to get something removed from the website. Instead of removing it or applying their use of terms, what Glassdoor did was they posted a badge basically saying to be wary of, cautioning users against us.
Okay, let me let the other side speak for 2 moments, and you also will have 2 minutes for rebuttal.
Thank you.
Okay, thank you very much.
May it please the court. That is not what the Communications Decency Act says. Just because Glassdoor steps in the shoes of an anonymous poster to defend free speech does not make it a publisher. It is an internet service provider. All the case law we cite makes it very clear that Section 230 provides immunity for this case. But I just want to take a step back, because this is not the Curlin Group versus big tech. This is a junior lawyer who dared make an unflattering opinion about her former employer, about the terms and conditions of her employment, and then get dragged into court for over 3 years, and the deterrence effect that has on everyone else, any other employee, not just of the Curlin Group, but anywhere else in New York, that says, if you dare say anything negative about me, I am going to sue you, I'm going to force you to retain counsel, I'm going to drag you through 3 years of litigation, and I'm going to make you spend money. That's what this case is about. Glassdoor stepping up and defending a junior lawyer's freedom of expression. Under any case that we talked about, these opinions about micromanagement, about the fact that overly micromanaging the emails, none of that comes close. It's not even.
So that's not actionable. I mean,
not
that's
actionable
it's
under-
just clearly opinion, is what you're saying.
Under failure to state a claim standard or under the anti-SLAPP standard. That's why this case cannot continue. We cannot have another remand, a remand. But one thing I want to.
That was my question. So I'm back to the Second Amendment complaint.
That's what I'm going to hit on
Third
next.
Amendment complaint. So it appeared that we were only dealing with the Second Amendment complaint.
Yep.
How do we then address the Third Amendment complaint?
Let me walk you through that, if I may, just answer the question.
Yeah, take a short walk through.
I will, because it will take a stroll.
No stroll.
Okay, so this is what happened. Okay, we filed a motion to dismiss the Second Amended complaint. The judge originally granted it, except he did not grant it as the defamation per se claim. We filed a motion to renew and re-argue and said you didn't consider the CDA and the defamation claim fails as a matter of law. What plaintiff did, and plaintiff is the one respectfully who caused this procedural mess, at that moment in time, plaintiff did 2 things. Plaintiff then filed a Third Amendment complaint, withdrawing all the claims except for the defamation claim against Glassdoor, added a new party, Ms. Shooter, with those 2 claims, but then simultaneously and afterwards filed our own motion to renew and re-argue the Second Amended complaint. So plaintiff is proceeding under 2 paths at the same time in this case. We objected. And then when Judge Engoron ruled on the motions to re-argue in the second amended complaint, he had in front of him not only those motions to re-argue by both sides, he also had our motion to dismiss the third amended complaint. And the court said, the third amended complaint didn't cure any of the deficiencies I outlaid in the second amended complaint. And Judge Engoron, on this order, on this appeal, not the other one, dismissed whatever complaint is the current one, which was the third amended complaint that was filed before his decision.
Did he make a decision in this case after this decision
Yes.
that I think is on appeal here today?
Yes. And all that
what
was,
did he-
though, but all that was, Your Honor, was clarification. We asked him to clarify, because after the judge issued his decision dismissing everything, plaintiff then filed a motion to hold us in default. And we said,
For
"Judge,"
not answering the third complaint. the
yes,
third
and,
amendment.
we said, Judge, what's going on here? You've already dismissed everything. Can you please clarify for us that your prior order, the one we're here on today, clarify that in fact you dismissed the third amended complaint?
Okay.
And he said, yes, in my prior order, the one here on today, yes, I dismissed the third amended complaint.
He said that in writing?
It's in the order. It's in that second order literally says that.
What's the second order?
The second order is the second appeal. It's the one that clarifies that I previously dismissed the third amended complaint in the order that we're here today.
Okay, so my question is that part of the appeal that you think you're here on today?
Well, no, it's part of plaintiff's appeal because I don't need to appeal a
plaintiff's.
clarification order. The first order already granted the relief I sought, which was dismissal of the third amended complaint. I didn't appeal.
What was
second order.
what was the date of Judge Engoron's clarification order?
I believe it was in April, but I can find out in 2
April of
seconds if I check.
2022?
No, it was in 2021. It was in April, I believe, April of 2021. It was after the third amended complaint was filed.
Okay.
But I can get the exact date for Your Honor.
That's okay. Thank you.
Okay, thank you.
You have 2 minutes.
Your Honors, the two main points that I want to make
Okay,
are,
so not to beat a dead horse. Is it your understanding that Judge Engoron dismissed the third amended complaint?
Judge Engoron did dismiss the third amended complaint in a different order not being appealed from here.
That was my second question. So you did not appeal the dismissal of that third amended complaint?
We do in a separate appeal that has not yet been perfected. This is just with regards to
You filed notice to appeal on that?
Correct. And you know that this order is only addressing the second amended complaint, because if you look at the order, it specifically notes which motions and what docket numbers are being addressed in this order. So the only thing before the court at this time is the second amended complaint. But the two important points here is that Gottwald cannot be ignored. The bedrock of stare decisis must be respected. And the court made a clear and thorough reasoned decision.
Let me ask you, Gottwald is a very recent decision from our court, our colleagues. What is the difference that is to the result in this case?
It will make all the difference in the world. And let me answer that by getting to my second point, which is that counsel would have you believe that 3211G is an advent of the new amended laws. 3211G has always been there. It's always been there. What defendants are attempting to do is to confuse.
But it was amended.
No. 3211G was never amended. The only amendments to the 2020 SLAPP suits are two things. One is that more people can avail themselves of it.
Right.
And two, in certain situations which are not met here, if defendants can prove, it's their burden to prove that there's no substantial basis in fact or law, they're as of right entitled to legal fees, which they did not do, and the lower court properly ruled that they did not do so. But let me get back to 3211G because this is critically important. 3211G is not 3212. If you look at the lower court's decision, the lower court is applying the standard of summary judgment of 3212, making us have to prove in advance before we even get started that we have a substantial basis by clear and convincing evidence in fact and law. That is not what SLAPP requires. SLAPP requires 3211G. So whether this was a SLAPP suit or was not a SLAPP suit is somewhat irrelevant because the lower court improperly applied a summary judgment standard to our pre-answer motion, and that is critically important.
Okay, does anyone have any further questions? I think you both answered all our questions. We will certainly take a look at this very carefully. We thank you both for coming in.
Thank you, Your Honors.
That's okay. We'll take a look in the record. Thank you.